Thank you, Tapua. Are we ready to start?
We are, my lady. May I call the matters into record?
Yes, just make sure the other judges are online. Thank you.
Thank you, my lady. In the High Court of South Africa, Gauteng Division, Pretoria, today is the 11th of April 2023. This is a full bench third court motion heard via Microsoft Teams before the Honorable Justice Collis J, before the Honorable Justice Malindi J, and the Honorable Justice Mota AJ. The cases are as follows. It is case number 32323 of 2022. That is the Helen Suzman Foundation versus the Minister of Home Affairs and Director General of the Department of Home Affairs. Case number 006386 of 2022, it's Vinderin Margarite and another versus Minister of Home Affairs and others. Case number 51735 of 2021, it's African Amity NPC and others versus Minister of Home Affairs and others. May it please the court.
All right, thank you. Mr. Butlander.
Thank you, my lady. I appear for the applicant in the Helen Suzman Foundation matter, together with my learned friends, Mr. McConaughey, Mr. Sakoa, and Ms. Kritzinger.
Thank you.
My lady, this is David Simmons. I appear on behalf of CORMSA, the intervening applicant in the HSF matter.
Thank you. Are you alone today, Mr. Simmons?
Lady, I appear alone today, but I was ably assisted in the pleadings and the filing of the heads of argument by Namonde Nyembe of the Johannesburg Bar.
All right, thank you.
My lady.
The first and second respondents.
Lady, I think that would be me. It's for some reason I can't see myself on the screen. I don't know whether you can see me.
I can see you, yes.
Oh, I don't know what's wrong.
Hearing for the first and second respondents?
I appear for the first and second respondents in the Helen Suzman matter, the CORMSA intervention matter, and the Zimbabwe Federation matter, the ZIF matter. I appear with Mr. Rosenberg, Mr. Adakari, and Mr. Ibrahim.
Thank you, Jamie.
And we also appear, Justice, for the Minister in the Department in the truck drivers application.
That's fine. Then the intervening party, the third respondent. That's the truck driver.
As may please you, my lady, Mujapelo MM. I wonder if I'm audible.
Yes, thank you, Mr. Mujapelo. Are you alone today?
No, I'm appearing together with Mr. Mtsweni and Mr. Musala for the truck drivers in the Helen Suzman Foundation matter.
Okay.
All right, thank you. Then the Magazire and the Zimbabwe Immigration Federation application.
Thank you, my lady. I appear together with Mr. Ramokhale for the applicant.
Well done.
Thank you, Mr. Nkaitube.
And
he's already placed himself on record in this matter. Then for the African Amity NPC matter. Sorry, Mr. Chitando, can you just switch on your microphone?
Apologies, Justice. I appear on behalf of the second applicant in this matter. I appear alone.
Thank you.
This is you, my lady. Mr. Magadi and myself here on behalf of the Minister in the African Embassy matter.
Thank you, Mr. Durance. Thank you. I think you would appreciate that there's 3 applications that have been enrolled for this week, commencing from today. And when we went through the papers, myself and the rest of the bench, we deemed it prudent to direct the parties to the fact that we need to allocate sufficient time for all 3 matters. And to this extent, we thought it would be best if we deal with the Vandera and Magadzire application on Thursday, in their practice note that they've filed, they've indicated they would require approximately a day to get through that argument. Mr. Nkaitobi, will that be in order with you?
Yes, my lady. We are not sure what the implications of that would be. Would that mean that Mr. Badlander's case is argued and there is a response to it, and then we argue our case and there will be a response to it?
Yes, we thought that's how we're going to deal with it, because we need to make sure that we have sufficient time for all three applications set aside, because we have to adjudicate all three applications this week.
Yes, no, we have no difficulty if Thursday is allocated for our case, and they will be argued in a sense separately from the other cases. So that would be fine. I'm just not sure what implications it has for the bigger case, but if that's the direction, we are happy to accept it.
Yeah, you are willing to stay online if you wish to sit through the main application, of course. But we just thought, it would be prudent for you to do it, for us to do it in this fashion.
I like Mr. Badlander, but I probably won't be sitting.
I'm sorry, Justice Collis. Ishmael Jamie for the Minister. Could I make a comment, please?
Yes, you're entitled to make a comment.
I still can't see myself for some reason, which is a bit disconcerting, but I understand the court and the other parties can see me and hear me.
Yes, we can.
So on that basis, I'll proceed. Justice, I don't know whether the bench is aware that Mr. Nakatobi has filed supplementary heads of argument in which he makes it clear that his client no longer seeks an interim interdict pending a review to be brought. He now says that he wishes to have his review application, as it were, heard together with the, if I can call it so, the main matter. So on that basis, we had prepared, they seek final relief. In other words, they seek similar, if not the same relief as Mr. Badlander and Mr. Simmons. So under those circumstances, I don't know whether that was factored in, or whether the court, in giving its direction, was aware of that. But it certainly would prejudice my client and our preparation. Sorry, Justice. There appears to be some disturbance.
Some sort of interference. Could you just wait a minute for us? Let's just see who is making that noise.
Certainly.
Apologies, my lady. It is Tuso Kumalo, but I've muted the participant, my lady.
Okay, thank you.
And also just to, sorry, Counsel, my lady, you're not visible on the screen.
Myself?
Yes, your screen is blank, my lady.
Oh, my camera is in fact switched on. Can you see me? Well, Mr. Jamie, you can't see me.
I can see the other members of the bench, but not you, Judge. Justice. None of us can see you, it seems.
Okay. I don't know what's the challenge there. Shall I switch off, and then switch on again? Has that been the position from the commencement of the proceedings?
Yes, Justice Collins.
Yes, my lady.
But it wasn't indicated to me at the time. Okay, let me try again. Just give me a minute.
Certainly.
I was too scared to. Please.
Yes. Can you see?
The mic.
Can you see me now?
I can, Justice.
Thank you. Right.
Sorry, Justice Collis, the point I was making is that I'm not aware whether the court has taken note of the fact that Mr. Nakatobi no longer seeks interim relief. He filed a supplementary head over the weekend, I think, in which he makes it clear that in light of the other parties' submissions that they were abandoning the interim relief. As I understand it, he can speak for himself if I've got it wrong, and that they would seek final relief, as does the other parties. And we prepared our argument on that, since getting that note on that basis. So I intended, in fact, when I addressed the court, to explain that I would be dealing with the substantive challenges and the nature of the decision and so forth across the board. And Mr. Rosenberg would deal with other aspects of the matter. So we're prepared to deal with all the applicants. And with respect, I would submit that we would be prejudiced to have to make an argument and then have to make it again and have Mr. Nakatobi make his argument when he seeks effectively the same relief only on Thursday. So we would request that all the applicants go first, just as the truck drivers argue their case as well, and we then know, as the respondents, what case it is we need to meet, because I think one of the aspects in this matter, which I'm sure everyone is aware of, is that it's been a very, very large example of moving targets and shifting goalposts.
Yeah.
And we need to know, in order to properly represent our clients' contentions, what precisely is being argued against us in the various applications. So we would respectfully ask that all of the applicants, including the truck drivers, go first, and then the minister's representatives argue second, as the court pleases.
My lady, I don't wish to interrupt, but might I say something on Mr. Jamie, which I think is in support of him? Is it convenient if I'm...
Yes, you may.
Thank you, my lady.
Taking up
My lady, I'm not sure whether you whether your clerk forwarded to you, because we like the bench were mindful of the concern about finishing. And so what we did was we sat down with all of the council across all 5 matters, even if you include the truckers, and we agreed on a timetable which would allow us to finish, in fact, by the end of the 3rd day, possibly at worst by the 4th day. But I don't know if you received that timetable.
What we've received is your note on oral, on your oral argument that you'll present. I don't know whether, and we've received it literally 15
No.
minutes. We're supposed to commence. I didn't receive any other document from my clerk.
No. It was an email sent last week. I'm told my connection is spotty. Can you give me one moment to change onto LAN? If you just give me one moment.
Yeah, that's fine.
My lady, I apologize. I will sort out the connection in a moment, but there was an email that was sent to your clerk last week on the 4th of April, in which we set out the proposed timetable in detail with the applicants to go first. Could I perhaps talk you through it if it's convenient?
Yeah, is it uploaded onto case lines?
No, but I will have it uploaded immediately.
Yeah, because if it's uploaded onto case lines, we would have seen it.
Yes, your clerk said she'd forwarded it to you, but perhaps there was an error of communication. Let me have it uploaded immediately.
I do not think the rest of the bench also
If you give me one moment, I'll get my attorneys to upload it.
Judge Malindi, did you have regard to it?
Thanks. It's being uploaded as we speak. Perhaps we could just wait for a moment.
I just want to find out from the other judges. Judge Malindi?
My sister did not have regard to that timetable because I have not received it.
So, yeah. Judge Mota?
The same is true for me.
Okay,
my sister.
thank you.
I do apologize for that, judges. I'd asked for it to be forwarded to you, but with hindsight, we should have uploaded it to case lines as well.
I think that the challenge was also, the court was in recess. It's the first day of the term today, so, to have just sent through stuff via email perhaps was a bigger challenge because we had worked on the matters, on the case line profiles of the matters.
Yes.
And it would have been brought to our attention had it been on case lines.
Yes.
Yeah.
It's being uploaded as we speak. Perhaps you would just give me a moment for it to be uploaded and then I can talk you through it.
Right. But Applicant Toby did not seem to have a problem with this matter being dealt with on Thursday. That's still the position.
Yes, no, we have no problem either way, my lady. I'm happy with Mr. Badlander's position. He will articulate it in a second.
Yeah.
We are also happy with your leadership's position.
Okay, thank you.
Let me be clear, my lady, we also have no difficulty. We're not trying to make life more difficult for the bench. We were trying to make life easier, which is the reason that we did the timetable. But we are, of course, in your ladyship's hands. And the email made clear, which will be uploaded in a moment, that it was all subject to the court's direction.
Yes, you see, Mr. Butlander, the challenge that we've had is we've had regard to what was uploaded onto case lines. And I take the point that you sent something through via email, but we've also had regard to the joint practice notes that have been uploaded onto case lines. And that's what informed our decision as the bench, because we are responsible to ensure that we get through the entire 3 applications with the allocated time.
Yes, my lady, let me reiterate, we are very much in your hands. We're not trying to be difficult, we're trying to help. Could I just take you to the relevant page on case lines and then we will leave it in the hands of the court. I don't propose to argue. The matter of a timetable is the matter in the hands of the court. It's at 061-1. And my junior has directed you there.
All right, I've had regard to the document. I suppose we would have to discuss it as the bench because we're only seeing it now. Thank you, Mr. Butlander.
Yes.
Okay. Is there anything else that you would want to,
Thank you, my lady.
To add? Sorry, Mr. Butlander, is there anything else you would want to add to this timetable?
Not from my side. Thank you, my lady.
Okay, thank you.
No, my lady, not from me. Not from me.
All right, thank you. Mr. Jamie?
Sorry, Justice. I understand Mr. Butlander has just given you the suggested timetable without, I'm not criticizing him, but he hasn't perhaps referred to or emphasized the changed nature of the relief that is sought by ZIF. And if I might be so as impertinent as to inquire, when you gave us your initial views and proposed direction that the ZIF matter be heard on Thursday, was the court aware of the fact that the relief had changed to now?
We were aware of it, yes.
Oh, you were?
We were aware of it, exactly.
Our difficulty remains, Justice, that it made sense to hear ZIF separately when they were seeking different substantive relief. In other words, an interdict pending a review. When everyone else was seeking a review, it would have been conceptually perhaps difficult to morph all those into one. Now that they seek a review, there is no reason we would, with the greatest respect, submit to have their application heard separately on Thursday. It would mean we wouldn't necessarily have to argue our case twice, and that may well lead to us not finishing on Thursday.
No, we will ensure that all parties do finish in time for the allocated time that's been allocated. But we have to have regard to the fact that we have 3 substantial applications that we have to deal with this week. And you argue the point that the other matter where they now seek a review, it's already before the court. The papers have not changed. Not so. They've applied for an amendment.
They've abandoned the interdict and they seek the same relief as HSF and COMSA. And
that's not their papers as it stands.
Those are the papers they propose arguing on, Justice.
Yeah, I understand, but it's not the papers as it stands on case lines currently.
The abandonment of the interdict.
No, the notice of motion that they've issued. But Mr. Jamie, I don't think we have to get into that argument right now. You've indicated your stance as the respondents. You would not want to argue a matter twice, given the stance of a change in stance taken by the applicant in the other matter, and we've heard you on that. But I need to consult the rest of the bench on it. I'm not sitting alone in these proceedings.
As the court pleases.
Yes.
I'm sorry if I've been too insistent. I apologize.
No, I've taken your position and I'll take it into account. Can I just indicate the other matter? This is the African Amnesty matter. That matter, when we went through the papers, we are of the view that we're going to deal with this particular matter, Mr. Chitando, on Friday. Do you have any issue to take with this matter being dealt with on Friday?
My lady, I've got no issues at all with that. In fact, it is particularly helpful because we received supplementary heads of argument from the respondents, and it was something that we're going to discuss. But I think putting it to Friday does help both the respondents and I. Okay.
Thank you, Mr. Chitando. Mr. Durant?
As it pleases my lady, I have no objection or qualms with your directive.
Okay. Well, your matter will be dealt with then on Friday, which is the 14th of April. We'll see you at 10 o'clock. You're welcome to remain online if you have the time to spare. If not, you'll excuse until. Justice Malinji, can you confirm that? That's what we've agreed.
That's what we agreed indeed. And if I may just ask Mr. Jamie, whether Mr. Jamie, is your proposal that all applicants move their applications and all respondents in the order of their applications then respond to all applicants at once without dividing the matters into 3 separate hearings.
It is indeed, thank you, Justice Malindi, that is precisely my request and proposal. Although the matters are brought separately, apart from the truck drivers application, which is a discrete application saying that the entire conception and execution of these regimes was from the get-go unlawful, all the others are attacks. So HSF, COMSA, ZIF are attacks on primarily, and of course Amity, where I don't act for the minister. Those 4 applications are attacks on the coming to an end of the ZEP, to use as neutral language as I can. And the grounds for those 4 applications are interwoven. Conceptually and legally, there was a distinction with ZIF because they sought different relief. They sought an interdict. They no longer seek that. So the result of them no longer seeking that is that the minister, in the 2 teams for the minister, myself and Mr. Durance, we are faced with 4 applications with interwoven factual, in fact, largely common cause factual, but interwoven legal submissions. And I submit it would be conceptually difficult for us, but also for the court to deal with the matters on successive days. It would be fragmented, it would be unnecessary, it would be unnecessarily time consuming because we'd have to rehash the arguments 3 times. And conceptually, with the greatest of respect, but also very importantly, from the point of view of my clients in those 3 matters, apart from Amity, where I don't act for the minister, we would be prejudiced were we not inconvenience in terms of time and just convenience, but inconvenience in the legal sense, were we to have to rehash arguments over and over again. So we do ask, and also we are entitled to know how the arguments fit together and what concessions are made in different cases in the different arguments before we deal with our response. And for that reason, we submit that we should be entitled, and the court should allow us to hear all the applicants who challenge the minister's decision, and then we respond as a whole and in one go.
Yes.
And that is my request. Thank you very much for clarifying that, Justice.
Mr. Chitando, save for the fact that you wish to consider supplementary heads, would you be amenable to Mr. James' suggestion, or do you still insist that hearing your application separately is still more convenient to your client?
Thank you, Justice. I just would like to deal with what Mr. Jamie said. I think it may actually assist him, considering what the understanding, I believe, on WhatsApp messages I've been exchanging with Mr. Durance. He'll speak for himself, I'm sure, after I've spoken.
If the parties may be conscious of the fact that we are not dealing with the real merits of their applications, but the convenience of disposing of this matter as quickly as possible. So there are 2 practical propositions made. The one that the court had already prepared as a directive for today, and what has arisen today. So it's a question of convenience, not the merits.
Yes, but I understand. I think I was actually going to speak on the issue of convenience, you see, because I believe the point that Mr. Jamie is making is that he would like to hear all of the applicants that are challenging his case. And I understand where he's coming from. He would like to hear everyone that is against him. But in my case, it is Mr. Durance. So Mr. Durance is going to have it will be the party with the benefit of hearing all of the applicants. If he so chooses, if he's going to sit as Justice Collis has said throughout the hearing until Friday. But Mr. Durance and I, from what I've gathered, we are happy for Friday. Mr. Durance will hear all the applicants. The ZIF, you'll hear Mr. Budlander and his team, and then respond, and then hear me, obviously, on Friday before him. And then he would have the opportunity on Friday to respond to everyone. So I think the concerns that Mr. Jamie has with the hearing on Thursday with ZIF is not the concern that he has with us. It's not with us, you see. So my view, it would be practical for us to be here on Friday, with myself and Mr. Durance having the benefit of the week to hear the others.
Thank you, my sister.
Mr. Martha, Judge Martha.
I have nothing to add at this stage, except that perhaps this might necessitate a bit of an adjournment for us to recalibrate the matter and think our way forward.
Okay. But for the African amity matter, are you amenable for that matter to be dealt with on Friday?
Precisely. I think it doesn't fit the exact bill with these other matters, so I think it would be prudent to deal with it on Friday and perhaps just refashion these other ones into a different format.
Okay. All right. So,
Could I just ask one question? So our position is still the same. If the court feels it's more convenient to hear us on Thursday, we'll be here on Thursday. If we're to be heard now, we will be heard now. But the one technical issue which your ladyship raised is whether we should now amend formally if there is an objection to the fact that we are changing our position to final relief, whether it is now required of us to put in an amendment. Maybe the government advocates can answer us, because it's really up to their client's position about whether there is any prejudice in the note we filed or what the position is.
would you want a response from them now, Advocate Nkaitobi?
At some stage, my lady, once you have given a directive about what's going to happen, at some stage we just need some clarity.
Okay. I was just responding to the argument that Mr. Jamie had placed before the court at the time when he argued for these matters to be dealt with from today onwards until Thursday, as the parties propose. So I think I suggest that what we can do at this juncture is we can take a short adjournment, and then we can inform the parties once we are ready about our directive for the hearing of the matters.
As you please.
So shall we take a 15-minute adjournment for that?
As the court pleases.
As the court pleases.
As the court pleases.
Okay. I don't know. Plugging in. I don't know, are these judges coming to me or what? I couldn't say to them.
No, but remember yesterday, you guys agreed that when there's a thing, they'll come here.
Okay. So,
Excuse me, there's someone who hasn't muted their mic so we can hear you.
Oh, yeah, it was the judge. I've just muted her. Thank you, Jamie.
Pleasure.
Okay. Just wait. Hold on.
Thank you, Depo.
Thank you, my lady. My lady, apologies on resumption of proceedings. And my lady, I confirm that parties eyes before the adjournment. May it please the court.
Thank you. We have considered as the bench the request made by the first and the second respondents through Mr. Jamie to hear the matters of the SHF as well as the ZIP matter together. That is not to result in a duplication of the arguments to be placed before the court. We are, however, not amenable to accede to this request. The directive of this court requires parties to file a joint practice note, and in the specific instance, that request directed through the Office of the Deputy Judge President was that the joint practice note ought to have been filed by the 15th of March 2023. The purpose of the joint practice note is to inform the court, give guidance to the court as to how the parties expect the court to deal with these matters that have been enrolled for this week, and similarly to inform the court of the allocated time to be assigned to the individual applications. Now, having had regard to the joint practice note, this court was informed that the African enmity matter will take approximately a day, as well as the ZIP Federation, the ZIP matter will take another day. In the joint practice notes that have been filed, there was no indication that the parties would require all three of these applications to be dealt with simultaneously. Now, it is also unfortunate that the email correspondence directed to the court was sent through on the 4th of April to the secretaries of the judges concerned and all other parties. This court is resuming the second term today, and as such, this email correspondence did not reach our attention as the bench. But this did not prevent the litigants from uploading this proposed timetable for argument onto the Caseline platform system. There's no indication as to why this was not done earlier to when the arguments actually arose this morning. It is for this reason that the proposed directive of the court of the court this morning stands. The Zip matter will stand on until Thursday. That is the 13th of April 2023 at 10 o'clock. And the African Amity matter will be heard standing down until Friday. That's the 14th of April 2023 at 10 o'clock. Mr. Jamie, if it would require that you would have to place a duplicate argument before the court, you are willing, when you present your argument, to inform the court when these other matters are to be argued, that your argument presented before the court in the earlier matter still stands on a particular point or points. But we cannot accede to the request that you've directed to the court.
As the court pleases.
Thank you.
As the leadership pleases.
Right, you then excuse Mr. Toby.
Thank you, Judge.
As well as Mr. Chitanda, Mr. Durance.
Yes, please, my lady.
Mr. Butlander, are you then ready to proceed?
I am. Thank you so much, my lady.
Okay.
My lady, at the outset, perhaps I could just explain what the note that was sent through this morning was. It's not a new set of heads. It is just my argument because of the complexity of the case. I had unusually written it all down, and I thought that it may be of assistance to the court to upload the notes so that the court doesn't have to take notes. I did tell my learned friend, Mr. Jamie, that it was coming, and I sent it to him in advance, and he hasn't indicated any difficulty, which I'm sure he wouldn't. He and I have an excellent relationship. So it's not anything more than what I was going to speak of, but it should hopefully make your life a little easier in going through it.
Right.
So, my lady, members of the court, thank you very much for clarifying the order. So as I understand it, what will now happen is that I will commence the main argument. My learned friend, Mr. Simmons, will then appear on behalf of COMSA. My learned friend, Mr. Mojapelo, will then have to deal on behalf of the truckers. And then we will have the minister to answer to everything. And then there will be replies from me and Mr. Simmons. And if the court deems it appropriate, and we'll leave that in the hands of the court, from the truckers. My lady, members of the court, if I could be...
Perhaps I could just ask you then, how much time do you envisage you're going to take with your argument? Because the proposed time has now changed.
I had thought an hour and 45 minutes, 2 hours max. So 2 hours to be safe.
Right, Mr. Simmons?
My lady, I had envisaged approximately an hour.
Thank you. For the truckers? Advocate Mojapelo, to switch on your mic for us.
Oh, thank you, my lady. We also think an hour will be enough for us.
Mr. Jamie?
As the court pleases, Justice Collins, between myself and Mr. Rosenberg dealing respectively with HSF, COMSA, and then the truckers, I think we would need at least 2.5 hours, maybe a bit more, maybe 2:45.
All right, thank you. Well, so you should be able to do it within the 2 days, because you literally have 2 days.
Yes.
Yeah. Okay. Then you may proceed then, Mr. Butlander.
Thank you. My lady, just to indicate in terms of a reply, I would need 30 minutes, but if the truckers are really going to speak for an hour, I might need more because I will need to respond to them. I might need 45, but I'll need between 30 and 45 minutes. I had bargained on 30, but they've now extended their time. But we will finish, and I think the sooner we get the show on the road, the better, if I may.
You may. Thank you.
Thank you, my lady. So, my lady, with your leave, let me say at the outset, we have filed 2 very full sets of heads, very full. The first is the main set of heads, which appears at case lines at 020-3. And the second is the set of heads that appears in the counter application, which is at 058-5. And we persist with all of those contentions. But what I hope to do in the course of this address, and that is the purpose of the note, is we will seek to try and deal with 4 main issues. And in doing so, demonstrate to the court the route through. Because it seems to us with respect that although you have a lot of paper in front of you, actually this case can be decided on a number of comparatively straightforward bases. And the relief, we, for example, taken 5 grounds of review. Now, any one of those grounds of review would be sufficient to grant the relief sought in the notice of motion. If you just upheld the Audi point, the other grounds of review would not be necessary to uphold the relief. If you just upheld the point about the failure to consider the impact on ZEP holders and their children, the other grounds of relief would not be necessary to uphold the remedy sought. And so what I hope to demonstrate to you during the course of this address is that actually on the papers before you, the case is really unanswerable on a couple of key points. And in that regard, your ladyship and your lordships will be able to cut a way through, because of course we are mindful of the fact that this is a judgment that has to be given swiftly, because as things stand, the ZEP permits will come to an end on the 30th of June. And so we are seeking, if we may, to try and make the court's life, as I say, as easy as possible, not as difficult as possible. So if I could then turn to the note, and I will be following the note, but the note appears at 060 on case lines, and my learned junior will from time to time direct you to case lines. And it is at 060 of case lines, and it begins with the oral address. And so the 4 points that I wish to address during the course of this address, my lady, are the following. Firstly, I need to deal briefly with the relevant factual context. Secondly, I will deal with the legal basis for this application, because there's been something of a late change from the minister in that score. Thirdly, I will deal with what I've called the 3 primary grounds of review. Now we don't abandon the other 2, but we just say that these are the 3, particularly the first and second, that are really quite straightforward to reach a conclusion on. And fourthly, I will deal with the just and equitable remedy. But before I do so, my lady, if I could just make a few brief remarks on certain critical issues. And the first is at paragraph 4 of the note. And this is the point that there is no dispute that the minister decided the fate of the ZEP program without prior notice to or consultation with ZEP holders and the public. Now, I've used that phrase, decided the fate, because I'll come in a minute to whether it's a termination or an extension. We'll come there. But the bottom line is this. The minister took a decision about what would happen to the ZEP program. And it is common cause that he took that decision without any prior notice to the ZEP holders or the public, and without any consultation with the ZEP holders and the public. And a call for representations was only issued in January 2022 after the minister's decision was announced. Now those facts are common cause, and I'll come in a moment to what the legal implications are. The second is that the minister, despite purportedly calling for representations, has repeatedly told ZEP holders and the public that he will not reconsider the decision to terminate the ZEP program. He's made that absolutely clear in words of one syllable, that he will not reconsider the decision to terminate the ZEP program, and that all that has changed is the grace period. It was initially a year, then it was extended for 6 months, which it will not be extended further. And we've pointed you in that regard to his press statement and various other places. The third is that there can be no genuine dispute that this decision has profound consequences for the lives of ZEP holders, their children, and the broader society. Just let me pause there. These are people who've been living in South Africa lawfully. And I know the bench knows this, but it's worth making clear, because some of the points particularly made by the truckers obscure this. There are lots of debates in our country about illegal immigration and what should happen to illegal immigrants, and do illegal immigrants have too many rights, or do they have too few rights? It's got nothing to do with today's case. Today's case is about 178,000 people who are here lawfully. They are here lawfully pursuant to a program put in place voluntarily by the government, and they have always been here lawfully for the last 13 years at least. That's what we're debating here. And so debates about, are our borders too porous or aren't they too porous, and should we be stricter or should we be more lax, it's all irrelevant, because we're debating here people who've been here for 13 years. Now, my lady, I don't wish to ask, one should never ask the bench a question, but if I could ask the bench to think rhetorically, where were you, I see Judge Motta laughing, where were you 13 years ago And how much has your life changed in 13 years? Well, I can speak for myself. I know my life has changed fundamentally in 13 years. I have changed my life. I've changed where I live. I've changed the number of children I've had in the past 13 years. And these are people who, during those 13 years, have done it in South Africa. They've built lives. They've built careers. They've had children. They've married people. They've had relationships. They've started businesses. They've become educated. And they've done it all lawfully, pursuant to a program put in place by the government. And so when we say that there is no genuine dispute, and the effect of this decision, it's common cause, the effect of this decision is that virtually all of them will have to return to Zimbabwe. Now, when we say there is no genuine dispute that this decision has profound consequences for the lives of ZEP holders, their children, and the broader society, that's why we say so. And the minister himself acknowledges that this decision will have an impact on national security, international relations, political, economic, and financial matters. And so, your ladyship, members of the bench, you can see where I'm going. We have a decision which is going to fundamentally change people's lives. And it's a decision which was taken without any attempt to hear them first. Common cause. It's a decision which the minister has told these people repeatedly he will not reconsider. And the question is, can that be lawful in our constitutional scheme? It might have been lawful under apartheid, because there was no right to a fair hearing in the same way, although even under apartheid, there might have been interesting debates about trial and legitimate expectation and all the rest. But in a constitutional dispensation, can a minister say to people who've been here 13 years lawfully, I'm going to decide your fate, I'm going to put in place a decision which is going to decide your fate and which requires you effectively to leave the country, without hearing them first? And we say no. We say if the Constitution means anything, and if PAJA means anything, and if the principle of legality means anything, that could never be the proper view. And I'll come to the detailed argument in a minute, but I'm just telescoping where we're going. The fourth preliminary point which I wish to make, and it's at paragraph 7 of the note, is that we need to be clear on the limits of the HSF's case. My client does not suggest and does not ask this court to find that the minister may never terminate the ZEP program. That is not my client's case, and that is not the submission I make. But my client does say, and I do submit, that because any termination has such profound consequences, in order to be valid, it must firstly follow a fair and procedurally rational consultation process. Secondly, be consistent with fundamental constitutional rights enshrined in our Constitution. And thirdly, be based on lawful, rational, and reasonable grounds. Now, those submissions are unremarkable, and yet they are treated as though my client is somehow trying to guarantee that the ZEP will be there forever. That is not my case. It's not my client's case. But if government wants to remove the ZEP program, it has to act fairly, procedurally rationally, in a manner consistent with constitutional rights, and lawfully, rationally, and reasonably. And as we are about to demonstrate, our submission is that the minister's decision falls palpably short of those fundamental constitutional requirements. And if that is so, then this court has no option. This court is required, with respect by section 172, 1A of the Constitution, to declare the minister's decision invalid. Why? Because that's what section 172, 1A says. It says that this court must declare conduct which is inconsistent with the Constitution invalid, and it must then grant an appropriate remedy. And I'll come to remedy. But let's start correctly. Let's start first with the declaration of invalidity. So against the backdrop of those points, my lady, I'm on page 060-3, paragraph 8 of the notes, and I wish to deal with certain of the relevant facts. We have set out the facts in great detail in our heads, but I just wish to emphasize a few of them for purposes of this argument. Firstly, if we could just deal briefly with the history of the ZEP program. It began in 2009, where the then minister, granted eligible Zimbabweans exemption permits under section 31(2)(b) of the Immigration Act, affording them rights to live and work in South Africa. Just let me pause here. I'm really not going to spend much time on the truckers, because they are an application of their own and they must bring it and we'll deal with it. But let me say, the suggestion that 31(2)(b) somehow doesn't allow a class of people to be given an exemption is just patently bad, because 31(2)(b) says you can grant an exemption to a person or a category of persons. Well, that's what was done here, with respect. So I say with great respect to my learned friends, I don't actually follow the argument, but no doubt we will hear about it in due course. But let me leave that aside. So in 2009, the minister introduces the Dispensation of Zimbabweans project to give legal status to over 250,000 eligible Zimbabweans who had fled the economic and political turmoil in their country. Let me just say, my lady, it's worth remembering that that's what caused all of this. There was massive economic and political turmoil in this country. The country was being flooded by people from Zimbabwe who were fleeing literally in order for their survival. And the government very responsibly and quite appropriately introduced this dispensation. In 2014, the DZP was extended and it was renamed the Zimbabwean Special Permit. In 2017, the ZSP was replaced with the Zimbabwean Exemption Permit, the ZEP, which is what we're dealing with. And we've given you the references the whole way along. Now, these exemption processes provided Zimbabwean nationals with a streamlined application process to obtain permits if they met the requirements and paid the necessary fees. And it's important, my lady, to emphasize that the ZEPs that were introduced in December 2017 were only available to those who held the original DZP in 2009. So if you were a Zimbabwean person who crossed the border in 2011 and did so unlawfully, and then you wanted a ZEP, you could not get it because you were not eligible, because the ZEPs, as the minister's own answering affidavit tells you, was only made available to those who held the original permit in 2009. And what that means, and we make that submission in paragraph 11, what that means is that all 178,412 ZEP holders have been lawfully resident in South Africa for more than 14 years. They followed the rules, they submitted their applications timeously and paid substantial fees. And on the basis of these exemptions, they have built families, lives, and businesses in South Africa. The 2017 White Paper on International Migration Policy, which is the government's own policy, recognizes the importance of these exemption programs. They advance national security, prevent corruption, and protect vulnerable migrants from exploitation and harassment. So that's the background. We now come to the present decision. And the present decision, we say, has two components. And we have highlighted it. I've just put one file in the wrong place, if you would give me one moment. We have highlighted it in our heads of argument. And we've given you the reference in the heads of argument for that purpose. The court would give me one moment. I'm just reaching for my correct file. Thank you. We've given you the reference. It's discussed in the heads of argument at 020-21, and it's paragraphs 49 through to 60. And what we say there is that the true nature of the minister's decision is apparent from the public statements and directives that the minister granted. And if you just go back a paragraph, if you go back a few paragraphs, we have at 020-16, you will see that we deal with the minister's decision to terminate the program, and we deal with the point at paragraph 38, where we say that Cabinet released a statement reflecting its decision to no longer issue extensions to the Zimbabwean special dispensation, subject to a 12-month grace period. And then we deal with the following points and the history. And we come up with a summary. And then if we could make the point, paragraph 47, that when it comes to the attempted consultation, which I'll come in a moment, the minister's attorneys respond to a ZEP holder saying, this is 47.2, due to the circumstances and reasons advanced in the letter that you have received, the minister is unable to reverse the decision. That's paragraph 47.2 at page 020-20. And then at 020-21, we deal with the nature of the decision. And we make the point that it's absolutely apparent that what has happened here is two things. It is a decision to terminate the exemption program, and it is a refusal to extend the grace period, firstly beyond the end of December 2022, but then ultimately beyond 30 June 2023. And those two decisions, we say, are the two decisions that go hand in hand. It is a decision to terminate, and it's a decision to refuse except for this initial grace period. Now, in their heads of argument, our learned friends attempt to recast the minister's decision, and I'm now at paragraph 14 of my note. They deny that there is any final decision to terminate the ZEP program. So they say, well, the only decision that the minister has taken is to extend permits until 30 June 2023. And the DG, we know, has previously claimed that no decision was taken to terminate all ZEPs. And my lady, it's difficult to understand how that submission or those points can be made seriously, because the minister's actual decision, the actual decision as communicated to ZEP holders and the public, is absolutely clear. And we show you that in paragraph 15.1. On 21 September 2021, the minister approved the Director General's recommendation, quote, to exercise his powers in terms of section 31(2)(d) of the Immigration Act to withdraw and or not extend the exemptions granted to Zimbabwean nationals. And that language is repeated in the January 2022 letters and notices issued to ZEP holders, which are headed non-extension of exemptions. And then the minister tells the recipient, the Minister of Home Affairs, and I'm quoting again, 15.2, the Minister of Home Affairs has exercised his powers in terms of 31(2)(d) not to extend the exemptions. And then this...
Sorry, Mr. Butler, it's not the applicant's case that the minister could not have acted in terms of section 31(2)(d) of the Immigration Act. Not
no,
no consultation prior to the decision.
Your ladyship has it exactly. The reason I'm spending so much time on it is because our learned friends try and avoid the consultation point and the irrationality point by saying, no, but there's no final decision on the way forward. So your ladyship has it exactly. We accept that 31(2) conferred a power on the minister to decide either to carry on with the program and extend or to terminate. We accept that. The question is, was that power properly exercised? And we say it wasn't, for the reasons I'm coming to. Your ladyship has it exactly with respect. And then just lastly, just to finish the point, 15.3, Scalabrini Center, one of the leading NGOs in the country in this area, writes to the minister about it, and the minister responds, I do not intend to grant exemptions in terms of 31(2)(b) anymore. And then the press statement accompanying the minister's latest directive says there will be no further extension granted by the minister. So your ladyship has it with respect. We don't run an ultra vires case. We don't say that the minister had no power to terminate the program. He did. But in order to do so lawfully, he had to do at least three things. And those are the three I'm going to come to. He had to engage in a fair and rational process, i.e. consultation, which he didn't. He had to consider the impact on Zimbabweans and their children who were subject to the permit. And as I demonstrate, he didn't. And he had to make sure he didn't breach fundamental human rights in the Constitution. And as I demonstrate in what follows, he didn't. So what we say, just to round off this point, is that the suggestion by the respondents suggest that the minister's decision is not reviewable because he has the power under 31(2)(b) to reverse it. So they say it's not disputed that the minister is presently of the view that the ZEP will come to an end in due course and that this is supported by cabinet. What is disputed is the implication is that the minister is prevented from some or other reason for considering the further extensions for the validity. Well, with respect, as things stand here, as we stand here today, if this court were not to hear the matter, or if this court were not to decide by the 30th of June 2023, the program will come to an end. That is the effect of the minister's decision. So to somehow suggest that, well, because it might be reversed somehow, somewhere, someday, maybe, this court should not intervene with respect is untenable. And we make the point that our courts are frequently called upon to review reversible decisions, such as an administrator's refusal to take a decision or unreasonable delays. And we've given us just one example, your ladyship's judgment in the Groundwork Trust case, where there was a refusal to create enforcement regulations that could have been reversed at any point, of course, and yet this court set it aside, quite rightly, because at the time that it came to court, there had been nothing that was done to reverse it. So the nature of the decision, just to summarize, we say has two essential components. It is A, that there will be a termination of the exemption program, and B, a refusal to extend the grace period beyond 30 June 2023. Now we come to the next point, and it's under the heading, the impact of the minister's decision. We make this, it's paragraph 19, and we say that the inevitable effect of the minister's decision is that as of 30 June 2023, tens of thousands of ZEP holders will be left undocumented. This is due to the legal and practical barriers to securing alternative visas and permits. We make the point that even where ZEP holders are eligible for alternative visas and permits, and the papers demonstrate the extraordinary difficulty in showing eligibility, they're unlikely to receive them in the next 3 months because of the undisputed backlogs and delays in the processing of applications. And you don't have to take our word for it. The SCA in Desard reflected on the prolonged and enduring departmental dysfunction and sloth on a grand scale. That's the SCA speaking about this department. Circulars issued by the department reflect ongoing backlogs and delays. The respondents admit that by September 2022, the minister had not yet decided any of the approximately 4,000 waiver applications submitted by ZEP holders, and the Departmental Advisory Committee acknowledged the mammoth task of doing so. So as we stand here before you, my lady, you have not been presented with any evidence of anyone who has applied for regularization of status, can I call it that, who has applied for a permit other than the ZEP permit, who was a ZEP holder and has applied for it, and who has been given it. You have not received any evidence of that. In September 2022, the minister had not decided any of them. And despite the fact that there was a 76-page supplementary affidavit, the respondents don't provide any more status information to you on the status of the backlogs, the steps they take, nothing. And this is despite the fact that these respondents, my lady, are subject to the heightened duty of candor in constitutional litigation to be fully transparent and disclose all necessary information to the court. The one thing you can be sure of, my lady, is that if those 4,000 waiver applications had been decided promptly and had been decided favorably, you would have been told about it, but you've been told nothing. And we lastly say, and then I will turn to the grounds of, to the legal basis, we lastly say that it's important to bear in mind the well-known principle that this court is aware of, bald denials and evasions in circumstances where relevant facts are in the respondent's knowledge do not establish a dispute of fact. And I'm going to come back to that in due course.
Mr. Butler, can we take the tea adjournment now?
Certainly, my lady.
To attend tea, actually. First
Thank you, my lady.
So we will reconvene at 25 to 12, 11:35. Thank you.
I believe so, my lady.
Thank you, my lady. Thank you, my lady. So I had, before the break, I had dealt with the factual background, and I was now turning to 060-8 of my note, which is the legal basis for the application. And it's necessary, my lady, to separate out what the minister's case was until yesterday and what the minister's case appears to be now, because there was seemingly a late change in the minister's case as of yesterday. So let's start with the case as it was until yesterday. Until yesterday, I understood the minister's case on the basis of the papers and the heads filed to be the following. He accepted that the decision was administrative action, which was subject to PAJA, and he accepted that even if PAJA didn't apply, this was an exercise of public power that was reviewable under legality. And the court will be aware, and I'll come back to it, that even if PAJA doesn't apply, the principle of legality is the safety net, which does apply, and I'll come back to it. And thirdly, he accepted that if it limited constitutional rights, any limitation must be reasonable and justifiable under Section 36 of the Constitution. And so the debate was not about which standards applied. The debate was, were those standards met? Yesterday, that seemed to change, because in a note uploaded yesterday, the Minister's Counsel suggested that his powers under 31(2)(b) are executive action, not administrative action. And although he doesn't say it expressly, he must be making that submission, or his counsel must, for purposes of arguing that PAJA doesn't apply. Now, I can understand why the Minister's Counsel want to argue that PAJA doesn't apply. I can understand that. It is because PAJA is destructive with respect of the minister's case. But with respect, the difficulty that the minister has is that this new notion that PAJA doesn't apply is, with respect, plainly unsustainable. And let me demonstrate why in the note, and I'm dealing with this at paragraph 27. And I want to deal with this first because after having dealt with the legal basis, I'm going to come to the grounds of review. So the minister says PAJA doesn't apply because this is executive action, it seems. And the first problem is that that means the minister is directly contradicting himself, because in the heads that he filed in response to the truckers over the weekend, he relies on PAJA to say that the truckers' challenge is out of time. So when he wants to get rid of the truckers' challenge, he says PAJA applies, but when he wants to get rid of our challenge, he says PAJA doesn't apply. Well, with respect, you can't have it both ways. The second problem is that it's inconsistent with cases from this court and other courts which have accepted that PAJA applies to ministers' decisions under Section 31(2)(b). We've pointed those out in our heads of argument at the footnotes 94 to 95. And we make the point that the refusal of Section 31(2)(b) exemptions has also been held to be reviewable under PAJA. Could I just say, my lady, I have asked my attorneys, your ladyship will know we already handed up or uploaded a full case bundle of the authorities in the main heads. Where there are additional authorities referred to in these heads or in my oral arguments, I will have them uploaded separately over the next day or so, just so that they're available to the court. But my attorneys are preparing a supplementary bundle.
Yeah, just have it indexed on case lines as additional authorities for the applicants.
Certainly, we'll make a note of that. Thank you very much, my lady.
Thank you.
So our courts have always accepted that PAJA applies to the minister's decision. And similarly, the SCA accepted that unreasonable delays in processing exemption applications under 31(2) are also subject to PAJA. So our courts have always said that PAJA applied, self-evidently. And the reason that they have is with respect obvious, because as we make the point in 27.3, the minister's decisions of exemptions are plainly administrative in nature. They are not executive because they involve the implementation of legislation, not abstract policy formulation. Now, it's true that there are difficult cases on the margins between, so let's take a step back, if I may. What the courts have said is, if something is executive action, let's take an extreme example, a decision to declare war. That's executive action. It's not subject to PAJA. But if something is administrative action, again, let's take a really easy example, a decision to grant a liquor license, then it is administrative action and it's subject to PAJA. And so what the courts say is the more it involves policy formulation and the policy underlying legislation, then it might be executive. But if it's the implementation of legislation, then it's definitely administrative action. Now, this case, self-evidently, is the implementation of legislation. It is the minister exercising a power which was given to him by Parliament. He is implementing legislation under 31.2.
Section 31.2.
Yes, 31.2.
Legislation Act.
Exactly. Your ladyship has the point. It's 31.2. The Parliament said to the minister, you may grant exemptions to persons or to categories of persons. And the minister exercises that power. He is implementing legislation. And we've given you the authority which says if he's implementing legislation, it must be administrative action.
And can the argument not be put forward that it's also a policy that the government has now adopted?
It's not, and I'll tell you why with respect, because policy is generally free-floating. It doesn't have legal effects. So when government adopts a policy, for example, like the white paper on immigration, which says we're going to adopt a particular stance, that has no legal effect on people's rights, and that's regarded as policy. This is a decision which has a direct effect on people's rights. It determines whether people will be able to live in this country after 30 June 2023. And the fact that there might be some policy considerations doesn't change that. It is a decision which affects people's rights, and it is therefore plainly administrative action. And that's the reason that case after case has held that when the minister implements, I beg your pardon, when the minister makes a Section 31B exemption determination, it is administrative action. And then lastly, and it goes to your ladyship's point, it can't be policy formulation because there is already a jurisdictional requirement that there be special circumstances. And we know that from from what the minister says in response to the truckers, because the minister's heads in response to the truckers, and we quote them, says the jurisdictional fact necessary for the minister to exercise his powers in terms of Section 31(2)(b) is the existence of special circumstances that justify the granting of an exemption. So it is inevitably a jurisdictional fact, and it is an exercise of legislative powers or giving effect to legislation. And we make the point in 27.3.3, the minister's powers serve to give effect to national policy on exemption regimes. That's the white paper, but they do not create, the decision does not create new policy. And then very lastly, the respondents somehow suggest, well, it's different when the minister creates a blanket exemption program, in other words, a category of people, rather than an individual. So the argument goes, if the minister grants an exemption to Stephen Budlander, that might be administrative action, and if he withdraws it. But if he grants an exemption to Zimbabweans falling into specified circumstances, then that's not administrative action. But that argument is plainly unsound, my lady, for two reasons. Firstly, an administrative act doesn't lose its administrative character just because it affects many people's rights, rather than a small number of people. And secondly, the creation of broad exemption regimes like the ZEP is a bureaucratic function. It involves setting timeframes for the application, setting the eligibility criteria, determining the applicable fees, the conditions to be attached to the permits, and the issuing of the permits to successful applicants. That's not high policy. That is the implementation of legislation, which is exactly what PAJA is designed to deal with. Yes, my lord.
If each of the 178 holders of ZEPs received a notice saying with effect from X date, your permit will be terminated or discontinued, would it make a difference to when the minister says the dispensation granted to Zimbabweans under the following circumstances is no longer being continued with in regard to policy and executive action?
Your lordship, with respect, has again put his finger on it. The answer is no. If the minister had, instead of making a public announcement, send out 178,000 individual letters, then he would have made 178,000 individual decisions, all of which would be admin action. The fact that he makes those decisions by a one overarching decision means it's still admin action. Your lordship is quite correct with respect. It would make no difference. In either event, it's admin action, and it demonstrates the point very neatly with respect.
Thank you.
So lastly, so we say with respect, this new argument that emerged yesterday, we understand why our learned friends try to advance it, but it doesn't help them. But even if it did, even if somehow Pudgett didn't apply, it still doesn't help, because the minister is still bound by the principle of legality. The minister, and just let's spend a moment on that, even if Pudgett doesn't apply, our courts have described the principle of legality as being a safety net. It is the safety net that catches all forms of public power which are not admin action. So even if Pudgett doesn't apply, the principle of legality covers as a safety net all forms of public power which are not admin action. And as I will come to in a moment, the principle of legality requires procedural rationality. And in this case, we are a mile away from procedural rationality. So, could I then turn against that backdrop, if I may, members of the court, to the first review ground, which is procedural unfairness and irrationality, and it is at 060-11. It begins rather neatly with the point that I have just made, which is if Pudgett applies, and we submit it plainly did, then the minister was required to comply with procedural fairness because Pudgett says so. And I think everyone accepts that, although subject to one little wrinkle, which we'll come to. If Pudgett didn't apply, then the minister was still obliged to take a decision that was procedurally rational, because the principle of legality requires that all decisions taken must be procedurally rational. Now, let me say, I accept that if it is not Pudgett, it doesn't always require a proper hearing. I accept that. It requires procedural rationality, which is not the same as procedural fairness. I immediately accept that. But what our courts have held is that if you are taking a decision, a non-admin action decision, and you are not affording people, affected parties, an opportunity to provide their views where, firstly, the decision being contemplated has a drastic effect on their rights, lives, and livelihoods, or there are persons and organizations with special expertise that would have a bearing on the decision under consideration, then in those circumstances, you are acting on a procedurally irrational basis, and the decision falls to be reviewed and set aside. Let me just spend a moment on that because it demonstrates the importance of the point. In the first case we cited for you there, ETV, the decision was not admin action. It was a decision about the, now this gets technical, it's a decision about when to turn off the terrestrial signal to move to analog. It was about the way we receive television. And the Constitutional Court, I mean, that really was arguably a matter of policy. And the Constitutional Court said, yes, it might be a matter of policy. It might not be Pudgett, but it is going to affect the way people in this country receive television, and it will affect whether some people get television at all. And so before you do so, you've got to act in a procedural way, rationally way. And so you must hear people. So you must consult them in advance. And so on that matter, which really is about policy, I mean, you think about the form in which we receive digital radio transmissions to our aerials. I mean, that is a long way away from anything I understand about, but it demonstrates that even there, the Con Court said, you must hear people. And they set it aside. Then in Scalabrini was the case cited in 31.2. Scalabrini was a case about closing a refugee reception office. Now that's a government office. It receives people who want to apply for asylum, and it receives their applications. And the minister, the same minister, a different person, but the same minister had taken the decision to close the refugee reception office in Cape Town. He said, no, I don't want to have one in Cape Town. I only want to have one in Joburg and Durban and Pretoria. That was the issue. Now, you would have said, well, are people really entitled to be heard about that? And the SCA held unanimously that this wasn't Pudgett, it was legality, but there were people, the Scalabrini Center and other NGOs in the refugee sector, who had a particular expertise about what this would do for people who were applying for asylum and the difficulties of applying in Cape Town instead of in Durban, or Cape Town instead of in Pretoria. And so what the court said is it was irrational to take that decision without consulting them. Now, if that's the case on things ranging from the way we receive our television signals in ETV to whether government should have an office in Cape Town or not in Scalabrini, how much more is it obvious that you need to have some rational process, some hearing process, before you make a decision that is going to put an end to the rights of 178,000 people to live in South Africa as they have for the past 14 years. It self-evidently is a decision that cries out for a hearing, particularly because the same sorts of organizations that the SCA and Scalabrini held had a special expertise, the Scalabrini Center, COMSA, etc. They had a right to be heard for exactly the same reasons. And I don't want to tread on Mr. Simmons's territory because he acts for one of those organizations, but COMSA certainly would fall into that. So we say, if it's PAJA, it has to be procedurally fair. We know that. If it's not PAJA, it has to be procedurally rational, and that means a right to make representations given the circumstances of this case. So now we come to what happened in this case. And of course, I've already told you what happened in this case. The common cause fact is that there was no call for representations prior to the decision. That is common cause. The call for representations was only made after the minister had taken his decision and communicated it. And the call for representations was meaningless because it didn't indicate the nature and the purpose of the representations. Now, let me deal with each of those, because for each of those reasons, there was no procedural fairness. One of them is good enough, but for each of them, there was no procedural fairness. Now, the starting point, and I'm now at paragraph 33 of the note, the starting point is that a meaningful opportunity to be heard generally requires that it be heard before the decision is taken. And the reason is with respect obvious. The reason is obvious because human beings, by their very nature, tend to make decisions best when they have an open mind and not when they've already taken a decision. And again, you don't need to take my word for it. We will upload for you the relevant passage from Hoekster. The court will be familiar with Professor Cora Hoekster and Mr. Glenn Penfold, whose book is the leading book on administrative law. And if my attorneys would just make a note, we should upload pages 529 to 532, because there they deal with this question squarely. And the point that is made, they say, is the ideal is a hearing beforehand, and this ideal seems to be reflected in the structure of section 3.2 of PAJA, which envisages notice of a proposed action and a reasonable opportunity to respond before any administrative action is actually taken and a clear statement of the action becomes necessary. So PAJA itself says it must be a proposed action, not something that you've done. It is ideal, so the authors, because as Corbett CJ noted in Attorney General Eastern Cape versus Blom, there is a natural human inclination to adhere to a decision once taken. And we all know that. When you tell your children the position will be X and the children then complain, they're much less likely than if you've heard them in advance, although there's no right to admin justice in my house. But anyway, it is easier to sway a decision maker who has not yet decided, and harder to persuade a decision maker to change a decision that has already been made. In practice, a hearing after the decision has been taken will seldom be as advantageous as a hearing beforehand. For this reason, as the Supreme Court of Appeal indicated in Nokia versus Minister van Correctieve Dienste, a subsequent hearing ought to be the exception rather than the rule. This is all Hoekster summarizing the jurisprudence. And then she says, it follows, as we see it, that an after-the-fact hearing will be procedurally unfair in the absence of compelling reasons why an opportunity to make representations cannot be granted before the decision is taken. So, we do not say that it is an absolute... Yes.
The very same book, if you go just a little bit further down,
yes,
in our code, however,
yes,
it is not always possible or desirable to offer hearing before a decision is made.
Indeed. Indeed.
Our common law recognizes that in a matter of agency,
yes,
or where a large number of people are likely to be affected, it may be impractical to give a hearing or hearings before the decision is taken. So I think that should also be taken into consideration.
My Lord, I know you're not going to believe me, but I was about to go to that very passage because I wanted to...
believe you.
Thank you. I wanted to draw your attention to that passage because I read that with some alarm over the weekend, and particularly the phrase about a large number of people. But when you read Hoekster's footnote at 196, she deals with that point about large numbers quite interestingly. she refers to the case of Nombungu in the Transkei, and she says, while the possibility of a subsequent hearing was not at issue here, so of course it was obiter, the case is of interest because the full bench readily rejected an argument that it was impossible to consult thousands of members of South African police. The court pointed out that only 34 members were affected, and there is no basis upon which the appellants can argue that to consult 34 members was beyond their means. And then Hoekstra adds in her comment, which is very important. She says, given the flexibility inherent in procedural fairness, it seems to us, that's her and Penfold, it seems to us unlikely that a large number of affected persons would ever in itself justify a hearing only after the decision is taken. It might, however, do so when combined with the urgency of the matter. So what Hoekstra is saying is the fact that there is a large number of people involved does not mean that you can dispense with a hearing before the decision. Sorry.
Can I also ask, because I think if you capture the essence of procedural rationality,
yes,
it's quite different from procedural fairness.
Yes.
So it's not exactly what is contemplated or thought of when you're looking at your section 3 of Baja or section 4 of Baja.
Yes.
So in essence, you're looking at the rationality in the process of reaching that particular decision. Now, yes, the fact that the minister, subsequent to the decision, does send out what seems to be akin to a desire to consult, would I not be able to look at that in that fashion?
No, I understand the question exactly with respect. It's very helpful. Can I answer it in two ways?
Yes.
Firstly, can I assume that Paja applies? Because for the reasons I've articulated, we submit Paja plainly does apply. Well, then, of course, as your lordship has correctly put to me, the test is procedural fairness, not procedural rationality. Yes. And on procedural fairness, the Hoekstra point is to say, invariably, it must be a hearing before the event, unless there are compelling circumstances. I just want to get her word. Compelling reasons why the opportunity, that's from page 530, compelling reasons why an opportunity to make representations cannot be granted before the decision is taken. Now let me just develop this, and then I'll come back exactly to your point on procedural rationality. If we're under Paja, I would ask, as we do in the heads, what are the compelling reasons? This is paragraph 41. What are the compelling reasons given in this case that justify after the fact consultations which appear from the affidavits in the case? And the answer with respect is that there are none. Because the only reasons, we say they're not compelling, but the only reasons that emerge is they say, well, in the heads, it says prior consultation would have been impractical. But that's a point made in the heads, not the papers. And that's not good enough, because what had to be pleaded was, these are the reasons I decided not to engage in prior consultation. And these are the facts, and this is why. And there is nothing in the papers to justify that.
And these are the obstacles we had faced or whatever.
Exactly.
It should have been the evidence, yes.
In fact, under Paja, I fully agree with you.
Right. Right.
It's not my area of focus, as you can see.
No, I understand that.
It's on that limited point, although the Constitutional Court has indicated that it would be irrational to find a decision to be procedurally or irrational under Paja and yet rational under principle of legality. So we should come to one conclusion. But more to the point, what about this procedural rationality?
No, I'm coming there, and I agree with respect. So if Paja applies, it's procedurally unfair for the reason I've given. Mm-hmm. If we are under legality, then we are here. And the test is, was there a rational reason for hearing people afterwards instead of before? Because the test of rationality, as you've correctly put to me, Judge Mota, my lord, is it's a different test. And you're right, of course, to say it's difficult because the Con Court has never quite explained how it can be that something can be procedurally unfair and yet rational. But never, leave that aside. Let me focus on rationality. The question is this. Rationality is all about means ends. It is, does the means justify the ends? That's rationality all the way back to pharmaceutical manufacturers. And when it comes to process, what that means is, what was the reason? What was the reason that this procedure was adopted? So if, for example, the minister had said, I had decided not to consult with people in advance because they had nothing to say of any benefit. Well, that would have been an impermissible reason, and the decision would have been irrational. If the minister had said, as you sometimes see in the customs cases, if I'd consulted, or the search and seizure cases, if I'd consulted them in advance, they would have spirited away the illicit goods. And so I couldn't consult them in advance. I had to consult them afterwards, because if I consulted them in advance, the goods would have been spirited away and the whole purpose would have been defeated. Then that would have been rational. So it all turns on, what is the explanation that you give for not consulting in advance? And I asked,
are we not hobbling because you did not use 53?
No,
then you
no.
ask for those reasons.
No, with respect, and I'll tell you why. Because 53 is primarily about the provision of the record, but we didn't have to use 53 because it's clear from Turner versus the Jockey Club that 53 is for the applicant's benefit. They don't have to use it. But more importantly, we pleaded here expressly that there was no procedural fairness and there was no procedural rationality. And if there was a reason for the government to adopt after the fact consultations, they had to put that up in their answering affidavit. Even if it had been in the Rule 53 record, that wouldn't have been good enough. They have to meet our case. And our case was, you didn't have a hearing before the event. That was impermissible. And they had to put that up in their answer. And that's why I come back, Judge Motta, to your question, or to the debate we were having. I say to you, rationality is about the reason that is given. Is the reason good or bad? And I ask with respect, rhetorically, what do these papers tell you about the reason that they consulted after the event? And my answer is nothing. If I'm wrong, my learned friends will point it out. But if somewhere in these papers there is an explanation which says, oh yes, the reason we consulted afterwards was because the goods would be spirited away or whatever, well then they will tell you. But I am unable to find any meaningful answer which justifies after the fact consultation. And given the presumption in our law, I don't mean a legal presumption, but I mean the understanding in our law that a hearing before the event is what is appropriate. There needed to be some explanation to meet even the low rationality threshold to depart from that. And there is nothing. And so in my submission, Judge Motta, whichever route you go, you come to the same conclusion. If it's Paja, it's procedurally unfair because there's nothing to justify going afterwards, and one would have to explain why you didn't go via the Paja route of 3-2. If it's legality, and I say it's not because admin action plainly applies, but if it's legality, there is nothing to justify, even at the level of rationality, why they did a consultation afterwards. And of course, let me say, it's particularly inapposite because the consultations afterwards, or the notional consultations afterwards, were done by means of sending letters to the 178,000. But what about the people who were not the 178,000? What about COMSA? What about Scalabrini? They didn't get any invitation to make representations. And so if we are going to take seriously the notion that there was an attempt to consult afterwards, there had to be a genuine attempt to explain why at least not the NGO sector as well. Because in Scalabrini, that's exactly what led to a complaint. There were no individual refugees or asylum seekers who said they hadn't been consulted. The complaint was Scalabrini wasn't consulted. And it was set aside, Judge Motta, on exactly that basis, which is it was procedurally irrational because Paja didn't apply, said the SCA. I argued Paja applied, the SCA said no, and the SCA said legality was good enough. So could I just finish this point by just running briefly through the points in paragraph 35 and following of the note? Because on 35 and following of the note, we make the point. The respondents contend that the consultation after the fact was justified because the minister was and is open to persuasion, and he had an open mind, and representations could still influence the outcome. Now, I firstly explained to you that that's the wrong legal approach. It's not about whether he had an open mind. He has to show that there are compelling reasons for going away from the general presumption that it's hearing first, decision afterwards. But never mind that, the assertion has no basis in evidence, because you haven't, and I'm going to come back to this in a minute, you haven't had an affidavit from the minister. In all of this paper, you have not had an affidavit from the minister, not a confirmatory, not a confirmatory, not a substantive affidavit. There is no affidavit from the minister. And the only person who can say, I was still open to persuasion, would be the minister. And I'll come back to that point in a minute. But it's not there. There's no affidavit from the minister. And in fact, the minister's public statements over the last 18 months have been clear that his decision to terminate the ZEP program is final and will not be reconsidered. And we've assembled those statements for you in our heads of argument, in the heads of argument of paragraphs 49 to 60. But just let me focus on two of them to avoid taking too much time. First, in the minister's letter of 19 February, the minister told Scalabrini, in no uncertain terms, this is a quote, there was no scope for reconsideration of the decision. So what it says is the attorneys for the minister and DHA received representations for reconsideration of the decision I have made from Zimbabwean nationals. They were informed that there is no scope for reconsideration, as the decision was taken after careful consideration and supported by the National Executive Cabinet. It has become practically impossible to continue with the exemption regime. So Judge Mota, to pick up on the point you and I were debating, if you are going to have procedural rationality because of an after-the-fact hearing, at the very least, you must be open to reconsider. But this is the minister in his own words saying there is no scope for reconsideration. And then secondly, in responding to the ZEP holders' representations, the minister's attorneys blankly asserted that due to the circumstances and reasons advanced in the letter, the minister is unable to reverse the decision. So the minister, at least in January and February 2022, was perfectly consistent. He sends out the invitation for representations in January, and later in January 2022, he tells both COMSA, he tells both the Scalabrini Centre and the ZEP holders that there is no scope to reconsider or reverse. Well, then what is the purpose of the representations? That is the very epitome of irrationality.
Then you get an extension up to June.
Yes, but that with respect is really a besides the point extension, because that was a brief extension, partly because of the litigation and the delays in the department. But the fundamental decision, which was at stake, the fundamental decision, which was that the program would be terminated, that fundamental decision was cast in stone. And he tells you that in his own words, there is no scope for reconsideration, and the minister is unable to reverse the decision. So we at paragraph 38, we quote the fact that the respondents accept that the right to a fair hearing is breached when an administrator has already made a decision and then contends that any other public participation would have made no difference. Well, they accept that, but that's exactly what the minister has done here. That is exactly what the minister has done. So our submission with respect is that, and we've made this point, Justice Mota, on the question you've just posed me about the 6-month grace period. That very point that I've covered is in fact written in paragraph 39, that it's the decision to terminate the ZEP program which is the real issue, and that decision, and even the 6-month decision, was taken behind closed doors. Let me say one other thing on this. Even if the minister had decided to terminate, but the debate was how long to give as a grace period, even that required a hearing. Let me give you the example. This court will recall from the main heads of argument, I'll just find you a reference, but from one of the other grounds of review in the main heads of argument, that the DG had proposed an extension of either 3 years or 1 year. I'll just give you a reference. The court doesn't have to go there, but at paragraph 216, we say that the Directors General of our heads, the DG's recommendation was that the minister consider extending the validity of exemptions for a period of 3 years, alternatively a period of 12 months. Now, assume that the minister can't make up his mind without hearing people, but assume that somehow he'd made up his mind that he's going to terminate, and that the only debate was how long is the grace period going to be, 12 months or 3 years. He had to hear people on that. He had to, because it makes an enormous difference in people's lives, whether they can spend another 3 years here or 12 months. But he doesn't. He goes for 12 months instead of 3 years. He goes against the recommendation of the DG. I'm not saying he's bound by the DG's recommendation. That's a different point. But he goes against it, and he does it without hearing people. So whichever way you look at it, members of the court, this is a decision that was procedurally unfair and procedurally irrational. And on that basis alone, it falls to be set aside. Just to finish the point about the fact that the invitation for representations was meaningless, we make the point in paragraph 42 that a call for representations is not meaningful unless it clearly demarcated as an opportunity to make representations on the specific decision. So you've got to tell people, this is what I'm thinking about, or even this is the decision and I'm now thinking of reconsidering. Please tell me what you think. That's what Pridwin held in paragraphs 192 and 206, and Sokela, the judgment of Mr. Justice Wallace. And the respondents give an inconsistent account of what their call for representations was. Sometimes they say the ZEP holders were asked to address the termination of the ZEP program. In another, they say the ZEP holders were invited to apply for individual exemptions. Now the vagueness of the call for representations is demonstrated by the sample of representations that the HSF received from the department. You'll recall that what happened was we asked for the representations, and they give the representations, and most of them are not representations about why the decision should be reversed, because nobody understood that that was the point. Instead, that it's pleading for advice and assistance, and all of them get an automated response offering no assistance whatsoever. So the other element, and again it goes back to Judge Morta's point, if you're going to rationally have a process where it's hearing after the event, the first thing is you've got to have your reasons, which is not there. But let's just leave that aside. Even if you had your reasons for and after the hearing, the next thing you have to do is you have to have an open mind, because otherwise there's no point. It was not there. And the third thing you've got to do is people have to be alive to the point of the representations. You've got to write a letter which says this. It says, I have made this decision. The decision is provisional. I have not yet finally made up my mind. I hereby call upon you to make representations as to whether I should reconsider. Now, nobody could read the DG's, could read the Home Affairs letters like that, and people didn't. And so on 3 separate reasons, no reasons for after the fact, no open mind, and no proper explanation, on all 3 of those, the process could never have been rational. Lastly, on this point, and I've made this point, in fact, but I'll just speed through it. At paragraphs 45 and following, we make the point that there was no public consultation and engagement with civil society. So even if it was rational or procedurally fair, which it wasn't in respect of individuals, what about the right of Scalabrini and other organizations with expertise to be heard? And there's no real answer to that except to say, well, neither the public nor civil society have anything to add to the debate. That is paragraph 50. Well, with respect, that is inconsistent with the Scalabrini judgment in the SCA. And more importantly, it's a no difference principle. That idea that you can make a decision without hearing people, and when they complain, then you say, well, it wouldn't have made any difference. It wouldn't have changed my mind. That has been rejected. I've actually lost count of the number of cases in the Concord. It was in Alpay, it was in Pridwin, it was in Kwelani. It's again and again and again. And the reason is that it's just not part of our admin law. So the suggestion, well, we didn't have to hear Scalabrini because they wouldn't have said anything different from the individuals. Well, of course they might have. They might have raised all sorts of policy considerations. They might have raised international law. They might have said, these are the people we speak for who don't have access to computers. They might have said 1,000 things, but they didn't because they didn't get a chance. So now we come to the last point. So far, where have we got to? Well, we've said procedural fairness can't be satisfied by an after-the-fact hearing and a lack of explanation. Procedural rationality can't be satisfied for all of the reasons I've given. And so we now come to the last point. And the last point is the new note from yesterday. This is, again, the last-ditch attempt. It's the new note from yesterday. And again, I understand why it's put up, but it's wrong. And the new note says something different. It says this. It says, there's no right to a hearing because the ZEPs were going to lapse by a fraction of time. And because they were going to elapse by a fraction of time, there was no need for a hearing. Now, the first thing to say is this. The way the note reads, you would think that there would never been any extensions. But of course, we know that there had been extensions. It was 2009, and then there was the first extension, and there was the second extension. But leave that aside. The first problem with it, and I'm now at paragraph 53, is that it mischaracterizes the true nature of the minister's decision, and it hides his agency. It would have been an interesting debate if the minister had simply let them lapse. Then we could have had an interesting debate about was this effluxion of time or not. But the minister didn't do that. The minister didn't just allow them to lapse. He took a positive decision that had two components. He decided to terminate the ZEP program, and he expressly refused to use his powers to create a further exemption in its place. That's the first part. And he granted a limited extension to 30 June 2023 while refusing to grant further extensions. Or even put differently, as I've argued he took a decision to grant an extension only of 12 months and then 6 more instead of the 3 years that the DG recommended. So whichever way you look at it, this was not simply a effluxion of time point. This was a decision by the minister that was taken. And so the suggestion that this is equivalent to the situation dealt with in the cases relied on in the last minute note, Peniti, Low, and Grootboom, is not correct. Those were statutory automatic dismissal clauses, where if certain things happened, you were automatically dismissed. There was no decision there to dismiss, no decision to extend, because it was statutory automatic dismissals. It was in that context, in Peniti, Low, and Grootboom, that the court said there was no right to a hearing, because there was no decision. It was an automatic consequence of law. And that's completely the opposite of what happened in this case. So that's the first reason, is that the cases relied on do not assist. But the second reason is that even where termination occurs by, and I'm now at paragraph 54, even where termination occurs by effluxion of time, a decision maker's refusal to act to reverse that automatic consequence has in certain circumstances been held to an administrative act attracting the right to a fair hearing. So sometimes even in an effluxion of time case, where something happens automatically, the decision of the decision maker not to intervene gives rise to a fair hearing problem. And we've cited for you 2 cases involving the Minister of Defense, Minister of Defense versus Mamasedi, and Minister of Defense versus Kulu. And in both cases, in the first one, the SCA said the refusal to reinstate a soldier who'd been automatically dismissed was administrative action, and the soldier was entitled to a fair hearing before the decision was taken. And in Kulu, the SCA held that the decision not to renew a fixed-term contract of a soldier whose contract was set to expire by a fraction of time was also an administrative act that attracted the right to a fair hearing. So the very effluxion of time principle, which our learned friends now try and rely on to avoid the fair hearing problem, doesn't assist them at all for the reasons I've articulated. And then lastly, there's a real debating point made. Well, we didn't give you a hearing when we granted the ZEPs, so now we don't have to give you a hearing when we terminate them. I mean, with respect, that point goes nowhere. Whatever should or shouldn't have happened before it was granted is neither here nor there. In the present case, there was no hearing. So where are we, judges? I've reached the end of the first round of review, and I respectfully submit, and I make the submission quite seriously, that there is actually no serious debate, that there is a breach here of a right to either fair procedure on the one hand or procedural rationality on the other, because there is no proper justification of this process and the failure to do so. And if that is so, then that by itself justifies the relief sought, because what that means is that the decision was invalid. The decision must be set aside, declared invalid and set aside. The minister will have to decide what to do next. And while the minister makes that decision, my clients are entitled to interim relief, which will preserve the status quo. I'll come back to remedy in a minute, but let me say, this ground in and of itself justifies the relief that is sought. And I make the quite serious submission that there is no answer to it. Justice Collis, members of the court, with your leave, could I then turn to deal with the second review ground, which is at 060-19. Now, we've reordered our grounds. You will see this was the third ground, and I hope I haven't confused. But it was the third ground in the heads, but we've moved it up because it seems to us, with respect, that just like the fair hearing point, there really is no answer on this ground of review. And it's a different ground, and whatever you decided on the fair hearing point, this would be a separate ground, and let me deal with it. This is the ground of review about the failure to consider the impact on ZEP holders and their children. And we've dealt with it in the heads you'll see at 020-75 to 020-80. But the point we make is this. This is a decision which required the minister to apply his mind to the impact on more than 178,000 ZEP holders and their children. That required, at a minimum, that the minister should have had proper information before him about who would be affected, to what degree, and what measures had to be put in place to ameliorate the harm, and he had to consider the harm. We're not saying that the 178,000 people, their rights trumped. We're not saying it was determinative, but it was plainly, to put it at its lowest, a relevant consideration. Now, could I divert from the note briefly to give you 3 case line references, which I think would be which I think would be helpful. The first, I'm just calling up the note. Yes, if I could begin by asking you to go to 001-74. My junior will take you there. And you will see there 001-74, paragraphs 157 to 160. You will see that we have pleaded expressly under the heading the third ground, which is now the second ground, that the minister's public statements indicate that no attempt was made to assess the impact on ZEP holders and their children before taking the decision to terminate. This is reinforced by the DG submissions. The decision of this consequence required proper information on who would be affected, to what degree, and what measures were put in place. It required careful assessment. Without this information, the minister would have ignored relevant considerations. It would have rendered any decision irrational and unreasonable. Pleaded squarely in the founding papers. And if you could make a note, you don't need to go there, but if you could just make a note, the DG submissions to the minister, which prompted the decisions, are at FA 8 00196 to 001-103. We don't have to go there because there is nothing to see there, because they don't deal with this issue. In other words, when the DG submits to the minister, this is what you should do. His submissions do not deal with this problem about the impact. And similarly, the minister's reasons issued on 7 January 2022, it's FA 15 001-128. I think we should just go there if my junior would take us there. 001-128.
Your junior is not directing us to the page. We're finding the pages on our own.
I'm so sorry. I thought you were being directed. I do apologize. I'm being directed. Perhaps there's a problem with the setting.
Okay.
Let me try and direct you there.
I'm there already. I'm just indicating when you say it's not happening.
I do apologize. Thank you. 001-128. You will see those are the reasons that the DG. Those are the reasons that the minister gives, and you will find that there is nothing there which speaks about the impact on children or the impact on ZEP holders. So we lay down the challenge in our founding papers, my client does, and my client says at the passages I took you to, you didn't consider the impact on the 178,000 ZEP holders and their children. And if you didn't consider that impact, your decision is irrational. Well, let me take you back to the note for oral argument. And I'm back at the note. I'm back at the note at 060-19. We make the point at 060-19, paragraph 59, that the respondents have provided no evidence at all, no admissible evidence, but in fact no evidence, that this impact was considered. Judge Collis, I see Judge Mota has frozen. I just wanted to check that he's still with us.
Yes, I can hear you.
Thank you, my lord.
It seems I am frozen.
As long as your lordship can hear me, then that's all right.
No, I can.
Thank you.
It's a good picture, don't worry.
Indeed.
Yeah,
so we make the point at paragraph 60, and this is really dispositive of the point, that there is no affidavit from the minister. There is no affidavit from the minister, not a main affidavit, but no confirmatory affidavit. Now, the decision in this case was taken by the minister, not the DG, not any other official. If it was taken by any of the others, it would have been unlawful. So the decision is taken by the minister. But that means that only the minister can testify under oath as to what materials and considerations he took into account. There is no affidavit. And just to jump ahead, what our learned friends say when we come to this point is they say, well, what can the minister say other than state that he considered this effect? Well, if he had said that, we could have that debate, but he doesn't say that because he says nothing. Now, that's not a technical point with respect. It's a very serious one. And we make that point in paragraph 60.3 by adopting the cases cited by our learned friends for COMSA in their heads. They cite the case of Gerhardt versus state president, which makes the point that one person cannot make an affidavit on behalf of another. And if you have multiple respondents and the first respondent says, this is what's in my knowledge, that doesn't change what's in the other person's knowledge. And so it concluded, that's Judge Goldstone speaking, insofar as he imputes intentions or anything else to the state president, it is clearly hearsay and inadmissible. And then there's Chantouche, where again it was a debate about what was before the person and what knowledge the minister had or the decision maker had, and the answer Judge Murphy gave is that cannot be so. One person cannot make an affidavit on behalf of another. The second respondent can only depose to matters in his own knowledge. Now that principle is so well laid down that it is trite, but you are faced with an affidavit, two in fact, without any confirmatory from the minister. And so this court has no admissible evidence from the minister at all on what he took into account in terms of the impact on the 178,000 people and their children. Nothing at all. Well, on that basis alone, this ground of review has to succeed because the challenge was laid down in founding, which is the reason I took you there. The only person who could have answered it is the minister, and the minister has not done so. On that basis alone, the ground of review has to succeed. But even if you were somehow to look past that and somehow impermissibly rely on the evidence from the DG, there is still no answer in this case to this ground of review. Because at 63.1, we point out that the DG submissions to the minister, which formed the basis of the decision, were entirely silent on the impact. I've made that point. On the DG's own version, the minister simply approved the DG's submissions on the same day without further interrogation. The minister's 7 January press statement, as I've taken you, was entirely silent on the impact. And in the founding affidavit, the HSF expressly invited the respondents to attach to their answering affidavit all relevant documents and records which were relevant to the minister's decision. And that was done, Judge Mota, in lieu of a Rule 53 record. And no informational documents were forthcoming. Now, I'm simply making the point that they had every opportunity. In the answering affidavit, the DG was content to make the bold allegation that the question of impact on families weighed heavily in the deliberations of the department and the minister. But there's no substantiation, there's no details, there's no information as to what information was considered, by whom, by when. It's a patently bald statement. The HSF then affords the respondents yet another opportunity to disclose these documents in its Rule 3512 notice, which called for all documents, including minutes of the alleged deliberations on the question of the impact of children and their families. And the response of the government is a blanket refusal. And finally, the September 2022 DAC report to the minister again makes no reference to the impact of the ZEP holders and their children. Now, the respondents' heads of argument fairly do not dispute that the impact on these 178,000 holders and their children is relevant. They accept that it's relevant. And they implicitly concede that there are no documents reflecting any consideration of this impact. But so what is their answer? Their answer is to respond by saying that the minister could do no more than state that he considered such effect. Well, as I said, we could have had an interesting debate about that if the minister had put up an affidavit, and we would have said that it's not enough to make a bald allegation, but there is no affidavit, and that is the end of it. Lastly, there's a point made to try and say, well, don't worry too much because the minister had the benefit of representations from the affected ZEP holders after the fact. Well, I've already dealt with that in detail. You can't cure this problem. It's the decision taken before the representations that is being reviewed, and you can't cure this by saying, I'll think about it later. So we submit with respect that on this ground too, the decision is patently unlawful. And that applies, to pick up on the debate I had with Judge Morto earlier, both under legality and under PAJA. Because if we're under PAJA, then section 62E3 of PAJA says that the decision can be called to be reviewed and set aside because of a failure to take account of relevant information, and this was plainly relevant. And 62H of PAJA says that the decision can be set aside on the grounds of reasonableness, which specifically must include the nature of the competing interests involved and the impact of the decision on the lives and well-being of those affected. So if it's PAJA, it plainly falls to be reviewed and set aside. If it's for the reasons I've given, and we've referred you to Beta Stock. But let me assume that I'm wrong on PAJA. Again, we say we're plainly right, but let me assume that I'm wrong on PAJA. Even under rationality, the minister's failure to obtain and consider information on the likely impact of the decision would render his decision procedurally irrational. And we've made that point in the heads, and we make it with reference to two cases. It's the ETV judgment, again, and the Democratic Alliance versus the President case, the case regarding Mr. Similani. Now, just to use that case, that was a case about legality review, not an admin law review. And the debate was, had the president had regard to what had transpired before the Jinwala Commission in dealing with whether to appoint Mr. Similani, and the Constitutional Court held that he had not, and that set aside on that basis alone. So it's exactly the same here. If there is a patently relevant consideration, which this is and is apparently conceded to be relevant, and that patently relevant consideration was not taken into account properly or at all, then on that basis alone, it falls to be reviewed and set aside. And we make that point at paragraph 67. The impact of the decision on ZEP holders' lives and well-beings is plainly a relevant consideration. The minister's failure to consider or call for relevant information on this impact was not rationally connected to the decision. At least one of the intended consequences of the grace period must have been to mitigate the disruptive effects. That debate about 1 year versus 3 years was patently about how people could regulate their lives in the meantime. But he doesn't get any information from anyone about which would suit people better, what damaging effects might result from shorter rather than longer. And the irrationality colors the whole decision, because the minister could only form a rational assessment with proper information. And so again, I say, in all seriousness, there is no answer to this ground of review. I see Judge Morta is waiting in the lobby.
Judge Morta, were you lost? Were you cut off?
Yes, I am now back. I entirely blame Council Secretary who tried to direct me, I think directed me to the wrong alley. Because since that statement that we should be directed, I got frozen. So now I think I'm back.
So that's the direction then.
Yeah. All right.
Judge Morta, I'm not sure how long you dropped off for, but I was really just following the note. So it is all available, but I'm happy to repeat anything that would be of assistance, of course.
No, it was not that long. We can proceed. I'm sure I'll be filled in by my colleagues.
At least, Judge Morta, at least this time you've accused my junior of behaving badly, whereas last time I was accused of behaving hot under the collar. So I won't do that again.
I thought we had gone past that.
We have indeed.
All right.
Okay.
So
just now about to finish off with the
second round. Just to summarize, we've got an issue which is patently relevant and critical to this decision, which is what is the impact going to be on 178,000 people, most of whom are vulnerable, and their children. And it's clear that that information was not properly was not considered at all for two reasons. A, there's no affidavit from the minister. That's the end of the point. But secondly, even without that, there is nothing on the papers to show that it was taken into account in any meaningful way. And if that point is good, then even if you somehow were against me on the procedural fairness point, then the relief sought can be granted. This ground by itself is sufficient to grant the relief. And again, it's sufficient whether PAJA applies or legality, and without even dealing with the question of constitutional rights. And I hope the judges will now see why we have put these 2 points first, because they are really a cut through what is a lot of paper and a lot of unnecessary complexity. Actually, if this case was about a liquor license instead of about 178,000 people and much heat and dust and light has been cast on us. If it was about a liquor license and the debate was about a hearing or the debate about a failure to take into account consideration, we would have been done in an hour, because these 2 points are really not capable of being answered. With that said, members of the court, could I turn to deal with the third ground of review? And the third ground of review is at 60-24, and it is the unjustified limitation of rights.
Perhaps before you go there, let me just satisfy myself that I understand you very well.
Of course.
So this ground, it's basically reliant on your section 28 of the Constitution.
It is given a constitutional bite by section 28, but even if these were only adults, the ground would still remain, because where you are making a decision that will affect where 178,000 people can live and who've been living in your country for 13 years, you have to take into account the impact on them. So Judge Motta, with respect, you're quite right to emphasize section 28, because you will be aware that in the Pridwin case, the court said that section 28 must always be taken into account, and the best interests of the child must always be taken into account by decision makers. And so I embrace that with respect. My only point is it would apply even if we didn't have it. It just wouldn't be as patently obvious with respect. Thank you. So now, Judge Carlos, if I may, members of the court, may I move to the third ground of review, what was the second in the heads, and that is the unjustified limitation of rights. And just to orientate the court, we're now moving away from the procedural debate in ground one, and we're moving away from the failure to consider relevant considerations in ground two, and we're moving into a substantive breach of rights in the third review ground. And again, I want to be clear, whatever your view of the third ground, the first two grounds would be sufficient, and we will leave it in the court's hands as to how it decides which grounds to deal with and in what order. But the first two grounds are sufficient. So if I could deal then with the unjustified limitation of rights, and I'll be coming back in this regard to section 28.2. Perhaps I should simply say, at the risk of belaboring the point, Judge Motta, section 28.2 has two roles in this case. The first role is, can I call it the Pridwin role, which is the need for a consideration of children's best interests before you make a decision that might adversely affect them. That fits under ground two, and perhaps even under ground one, because there was no chance for the children to make representations or their parents to make representations on their behalf. So that's the procedural element of 28.2. But 28.2 also has a substantive effect, and the substantive effect comes in the third ground. It just occurred to me I should be clear that 28.2 permeates the first three grounds.
Yes, yes.
Thank you. So on the third ground of unjustified limitation of rights, everyone seems to accept that the minister's decision is subject to analysis under the Bill of Rights. The minister can't make a decision that violates the Bill of Rights. And so there are really two questions. The first question is, has a right been violated? And the second question, has a right been limited? And the second question is, if a right has been limited, is it justifiable? And could I deal with those two separately? Because that is the way the Constitution requires it. Now our submission is that the decision indeed limits fundamental rights, and the fundamental rights that are limited are twofold. It's the right to dignity, and it's children's rights under 28.2. Now, the minister says that there is no limitation, but with respect, the minister has to try and explain how there can be no limitation. We'll debate justification in a minute, but just let's deal with limitation. How there can be no limitation of a decision which forces 178,000 people and their children who've been living here for 14 years to leave the country. How can there be no limitation on dignity where the Constitutional Court has explained that the right to live in a country with proper documentation is essential to a life of dignity, which includes, quote, the enjoyment of employment opportunities, access to health, educational, and other facilities, being protected from deportation and thus from a possible violation of his or her right to freedom and security of the person, and communing in ordinary human intercourse without undue state interference. That quote is from Saidi. Saidi was a case about simply the renewal of permits and whether temporary permits could be renewed. And the Constitutional Court explained that the question of whether a permit could be renewed timelessly directly impacted on the right to human dignity for the reasons that I've articulated. Now, if that is so about a refugee permit, how can it not be so about the ZEP permit? Now again, I don't say that means they have to be valid indefinitely. I don't say that means they're absolute. I'll come to limited justification in just a minute. But it certainly shows limitation of the rights. Secondly, children's rights. We've made the point that children's rights include the 28(2) right that their best interests must be afforded paramount importance. And the papers demonstrate, and it's paragraph 149 and follows, that the minister's decision exposes children to the risk of family separation. It will render many children of ZEP holders undocumented, which threaten their access to basic services, including education and healthcare. These are children, many of whom have only known South Africa as their home. If they were born 7 years ago, they've only lived here for 7 years. If they were born 14 years ago, they've only lived here for 14 years. They've never lived anywhere else. And now the effect of the decision is that they must leave the home they've known for all those years and leave. Again, I don't say that means there's an absolute bar. I'm not dealing with limitations analysis yet. I'm dealing simply with whether there is a limitation. And I submit that it's difficult to understand how there could be no limitation. I see there's a Mr. Hlongwane who's on screen. Perhaps he could turn off his camera.
Apologies, my lady. Mr. Hlongwane, please switch off your camera.
Thank you. I'm always worried when someone comes on, they're going to have a point that I haven't thought of, but I'm glad that in this case, that's not the case and we can proceed. So we make the point that when it comes...
Sorry, Mr. Butler, please just control these people.
Noted, my lady.
Thank you.
So the point we make is that there is plainly a limitation of rights. Now, what is the response from our learned friends? Well, they say at 74, or 74 we've summarized, they say the exemption permits always had an expiration date, and the coming to the end of an exemption, which was always temporary, does not implicate the right to dignity simply because it has come to an end. But of course, this overlooks a number of things. The first is the fact that the exemptions have repeatedly been extended by successive ministers for more than 14 years. So they were not temporary in that sense. Secondly, it masks the true nature of the minister's decision. He took the active decision to terminate and has expressly refused to establish any exemption program in his place. But equally importantly, I take the example of Saidi. Saidi was about temporary permits to sojourn pending the outcome of your asylum application. They were temporary. And the debate was, well, if they're not renewed, is your dignity affected? Even though they were temporary, the Con Court said, of course your dignity is affected. So we're not debating permanence. We are debating the effect of the permit coming to an end. Secondly, the respondents argue that if the ZEP holders' rights are limited, then this would mean that the ZEPs could never be withdrawn and would become permanent. But that is, with respect, a sleight of hand because it ignores the two-stage limitations analysis. You've got to keep clear with respect the two sections, the two questions. Is there a limitation? And if there is a limitation, is it justified? We are, for present purposes, only debating the first section. Is there a limitation? And if there is, then we'll come onto the justification analysis thereafter. But you can't say, well, that means you could never take them away. Of course not. You could always take them away, provided that if there is a proper, reasonable, and justifiable basis for it in terms of Section 36 of the Constitution. Thirdly, the respondents claim that if this court finds that dignity is limited, this would have implications for all sorts of other visas and would undermine the very purpose of the immigration regime. But of course not, with respect, because all parties accept, everyone accepts that the ZEP holders are in a unique position. The court is asked to do no more than assess their unique circumstances and the justification provided for their limitation of rights. Fourth, the suggestion is made that the alternative visas and permits adequately protect the rights of children and ZEP holders. I've already made the point to you. You have not had a single example of a person who's been granted such a permit on the basis of the 4,000 who'd applied. And of course, we've told you about the delays on the basis of the SCA judgment in Desard. And finally, the suggestion is, well, the ZEP holders have been afforded an opportunity to make representations on their children's interests. Well, I've dealt with that already. So we say there is a limitation. And I need hardly remind this court that the Court's approach since the earliest days of Makwanyane has been that you interpret limitations, you interpret rights broadly. In other words, you reach limitations conclusions relatively easily, and you only deal with justification at the limitations analysis. So because we have a two-stage constitution, the Court has said time and time again, you interpret rights broadly at the first stage, and you worry about the justifications at the second stage. So there's plainly a limitation. But now we come on to whether the limitation is justifiable. And we do so at paragraph 75 and following. And when you do that, it becomes clear why our learned friends are so desperate to avoid a conclusion that there is a limitation of rights. The reason is because once there is a limitation of rights, the onus is on them to demonstrate that the limitation of rights is reasonable and justifiable. And this requires cogent factual evidence to support factual claims. And that is made clear by case after case. We've referred you to NICRO, we've referred you to Teddy Bear Clinic, it's trite law. And the problem is that there is no such evidence, and that the reasons given are insufficient given the extraordinary rights violations. And if I could deal with each of them in turn quite briefly. The first is alleged budgetary constraints. So the contention is, well, we don't have the budget. But the trouble is that there is no proper evidence that is provided to justify this budgetary constraint. And we've referred in our heads in paragraph 186 through to 190 to this issue. We've made the point that the minister referred to unspecified budgetary constraints and stated that a decision has been taken to prioritize services for South African citizens. And then there's a bald allegation about COVID, but no further details are forthcoming. And we've made the point that in Rail Commuters Action Group, the Constitutional Court made clear that the evidentiary requirements that must be met before an organ of state can successfully invoke budgetary constraints for limiting rights are high. And it said an organ of state will not be held to have reasonably performed a duty simply on the basis of the bald assertion of resource constraints. Details of the precise character of the resource constraints, whether human or financial, in the context of the overall resourcing of the organ of state will need to be provided. And then we go on and we analyze this, and then we make the point at 189 that the minister's press statement claimed that the total costs of exemption programs to the state was 188.7 million over the course of 10 years, so less than 20 million a year. And yet there is nothing to substantiate that alleged expense. The minister doesn't even account for the revenue earned from exemption permits, and on the figures provided by the minister himself, the ZSP and ZEP programs generated approximately 366 million rand in this period, more than double the alleged costs. So the budgetary constraint with respect is not tenable. Then there is the allegation of alleged improvements in Zimbabwe, but the problem with that, of course, is that these are unsubstantiated. We deal with in the heads at paragraph 176, and we make the point that there is no dispute that the rates of extreme poverty have increased in Zimbabwe from 2009 to 2020, that inflation rates continue to spiral, political instability, violence, and human rights situation. But more importantly, what it overlooks is that even if that were so, these are people who have been in this country for 14 years and have built their lives here. So even if you assume at best for the minister that everything is hunky-dory in Zimbabwe, the question is there enough justification to send people back to a country which they left 14 years ago and where they've built their lives here? The third point that's made is the alleged backlogs in the asylum system, but we make the point that it's difficult to understand how that's relevant, because the termination of ZEPs is likely to result in an increase in the number of asylum applications, not a decrease, because these are people who by definition got given these rights in 2009. So that point is simply irrational. And then we make the final point at 77, which is there is a deeper flaw underlying these attempts at justification. None of the respondents' justifications attempt to address the severe impact of the minister's decision on the rights of ZEP holders, nor do they explain why the minister did not explore less restrictive means to address the alleged challenges within his department. And it's worth, I know this court is well aware of Section 36, but it's worth just spending a moment on that. Section 36 says that a limitation of rights has to be reasonable and justifiable in an open and democratic society. And then it lists 5 factors that you must consider. One is the nature of the right. One is the extent of the limitation. One is the importance of the purpose of the limitation. Sorry, one's the purpose of the limitation, one's the importance of the purpose, and then the last is the less restrictive means. And so in every case in which the Bill of Rights is at stake, one of the factors that has to be taken into account is this the least restrictive means available? Is there another way of doing this that would be less restrictive? And let me give you one example, just one. The example is what the DG proposed. He proposed a 3-year period to allow people to regularize themselves, not a 12-month. Well, that by and of itself is a less restrictive means. And there's never been any proper explanation as to why that was not adopted. But there are many others. They could have increased the fees on the ZEPs. They could have changed this. They could have done all sorts of things. They could have created a pathway through to naturalization. They could have done many things. But there is simply no genuine attempt to weigh up, on the one hand, the impact of these limitations versus the reasons, and then consider the
Are you not speaking from both sides of your mouth, Counsel? On the one hand, you are saying we're not insistent that the ZEP should be granted citizenship, but at the same time, your suggestions are clear. They're geared towards that direction.
No, with respect, Judge Moto, they're not. And let me say why. I do appreciate the point. One of the options I raised was the path of naturalization, but many of the others do not involve that. So, for example, the debate about 3 years versus 12 months is not a debate about naturalization. It is a debate about how long people have to uproot their lives.
That's a DG's proposal.
Yes, but it's a DG's proposal that demonstrates that there is a less restrictive means available. And the debate here is, why didn't the minister adopt the less restrictive means? Because it's plainly less restrictive to say 3 years rather than 12 months. But there are any number of other ways. If the problem was budgetary, then why couldn't they increase the fees if that was the issue, or propose some sort of annual fee in order to renew, or there are any number of ways that you could do it. So I accept that naturalization is one option, but it is by no means the only option, and we're not asking this court to suggest that.
But in relation to the relief that you are ultimately seeking, on case lines, you had not proposed a proposed draft court order in the event of the court finding for you. What are you looking at?
Yes, it is the notice of motion, and I was going to take you there, but I wonder whether and we will upload the wording of the notice of motion in a draft order, but I wonder whether it would be convenient to take the lunch adjournment 2 minutes early, if that would be convenient, and then I just have remedy to deal with, which I will complete in the 15 minutes that I have left, if that would be convenient, my lady.
Right, I think Judge Malindi, is that in order if we adjourn now and we'll reconvene at 2?
That is in order, my sister, but Mr. Butlender can just help me as to when did the rights vest in relation to the period from 2009?
Yes. So let me start, if I may, Judge Malindi, with a different point. The Bill of Rights is clear that it applies to all people who live in South Africa or are in South Africa. That's been clear since the 2004 Lawyers for Human Rights case, even people illegally, but these are not. So these people became the bearers of those rights in 2009. But your question, with respect, it seems to me, asks something slightly different. If, for example, the program had terminated in 2012, I think your question, if I'm not putting words in your mouth, is if it had terminated in 2012, would that have produced the same violation of rights that occurs now? Have I understood the question correctly?
Indeed, because we are dealing with different dispensations and extensions, so that we are clear as to when, if there's such a contention or counter contention as to the vesting of their rights.
Yes, so my answer is these people became the beneficiaries of the rights in 2009. the right to human dignity, the right to children's interests. But I accept that if, for example, the program had terminated after 3 years, then, to put it one way, the limitation of rights would not have been as severe, because you would have had people who would only have been here for 3 years, not 14. You would have had children who would have been here only for a brief period, and the hardship created might have been lesser. So they would have been the bearers of rights, but we would have had an interesting debate about whether there was a limitation, and if there was a limitation, there would arguably have been easier justification. Where we are here is we are viewing it retrospectively, and we are viewing that one way or another, government has made decisions to allow this group of people to stay in South Africa for 14 years. And having done so, the limitation of rights is acute. It's particularly acute, and it therefore requires a very strong justification. Let me give you this example. Suppose that you have someone who enters into this country on a work visa, and the work visa is just for 3 months in order to do some particular job. The courts would undoubtedly look very skeptically on him if he said, no, but my rights are violated now that I've got to leave the country. It's a very different, he has the right to human dignity because he's in the country, but his rights would not easily be said to be limited. Whereas in this case, people who've been here for this long and have developed lives here have a much stronger case. So it seems to me, with respect, it's not so much a case of rights vesting. The rights vested the moment they were in the country, but it's a question of how strong are the rights, and how strongly are they limited, and therefore, or how severely are they limited, and therefore how strong does the justification need to be. And for that point of view, we must view it for the whole 14-year period.
Thank you, Mr. Patland.
Judge Mota, is it okay if we adjourn now?
Yes.
And you have a question?
No, it's fine.
All right, so Mr. Jamie, we'll then reconvene at 2 o'clock.
As the court pleases. Thank you, Justice.
Thank you.
Thank you, my lady. to be addressed was the question of remedy. I wonder if I could address that now. And could I start by taking you to the draft order, which has been uploaded, which you will find at 062-1.
Thank you.
Thank you, my lady. My lady, I should say for the assurance of my learned friends that this draft order just mirrors the amended notice of motion. There's no changes, except that we've added in the number of counsel we're seeking costs for, but I'll come back to that in a moment.
Could I just ask around the amendment, was that now agreed to that your notice of motion will be amended?
There was no objection to it. So
No.
yeah, there was no Rule 30 or anything else. So my learned friend, Mr. Jamie, will correct me if I'm wrong, but we've all argued the case on the basis that the amendment was effected.
All right, thank you.
So then if I could work through the notice of motion and then come to the principles, and I could also indicate where the disagreement between our learned friends and I arise to the extent that there is disagreement. So prayer 1 is really just that the decision to terminate the ZEP and to grant a limited extension is declared unlawful, unconstitutional, and invalid. And prayer 2 is that the decision is reviewed and set aside. And prayer 3 is that the matter is remitted to the minister for reconsideration following a fair process that complies with the requirements of sections 3 and 4 of PAJA. Now, as I understand my learned friends' heads, they accept that prayers 1, 2, and 3 are appropriate if the court is with us on the merits. Of course, they say that the court should be against us on the merits, but they accept that it's appropriate if the court is with us on the merits. Just one point to draw attention to. If the court were to conclude somehow that PAJA is not applicable, but that only the principle of legality is applicable, then of course prayer 3 would need to be amended to say a rational process that complies with the principles of the complies with the requirements of the principle of legality. So if PAJA applies, you can grant prayers 1, 2, and 3 in their current form. If PAJA doesn't apply, you would simply need to amend prayer 3 to provide for the principle of legality. But I doubt that my learned friends will have any difficulty with that, and they've quite properly, I think, accepted that that would be the order to be granted. The real debate is not that. And let me say, of course, that the prayers in 1, 2, and 3 flow from this court's duties under section 172(1)(a) of the Constitution, which says that the court must declare conduct inconsistent with the Constitution to be invalid to the extent of its inconsistency. And of course, the idea of a remittal, which is what we've asked for, we're not asking the court to decide how long the program should continue or anything of that sort, and I'll come back to that. It's a remittal back to the decision maker, and that is generally the appropriate order to be granted when reviewing and setting aside. That then brings us to prayer 4, which is the real debate. Now, could I firstly read prayer 4, and then could I, because our learned friends, at least notionally, take issue with it. And prayer 4 says this: it says, pending the conclusion of a fair process and the first respondent's further decision, in other words, you remit back, and pending that further decision, it is directed that existing ZEPs shall be deemed to remain valid, and ZEP holders will continue to enjoy the protections afforded by Immigration Directive 2021, which was simply that effectively exemption holders could continue to remain lawfully in the country and wouldn't be arrested. And that's all it says. So prayer 4 is really an interim position. It does not leave the ZEP program in place indefinitely. It quite deliberately and expressly leaves it in place only pending the minister's new decision. And it's important to appreciate that, because what our learned friends say, and we've addressed this in our note, but what our learned friends say is they say, no, but this is a substitution decision. You're effectively usurping the minister's powers. And that's, of course, not right. It would be a substitution decision if what this order said is it's to remain definite, it's to remain in place indefinitely, or it's to remain in place for 3 years, or anything of that sort. This court is not asked to make such an order. This, linked with prayer 3, throws the matter back to the minister to say, okay, your decision's been set aside on procedural grounds, or because you didn't consider the relevant considerations, or on any basis. Now you must take a fresh decision. and you must take a fresh decision. But while you are taking that fresh decision, these people's rights have to be protected. And so if the minister takes...
In other words, are you saying that the status quo will remain and they will face deportation?
That's all that it means. Exactly. Exactly. It is a status quo order. And if that order is not granted, if you were just to grant, let me say, it's in the minister's hands how quickly the minister takes that decision. The minister might decide to take it quickly, within 2 months, and then this order will only last for 2 months. Or the minister might decide to take it slowly and commission inquiries and do all sorts of things, and then it will last for that. But that's in the minister's hands. All this is a status quo order. And it's important to understand how calamitous it would be if you didn't grant this order. Let's assume that you grant prayers 1, 2, and 3, but you refuse prayer 4 because of what the minister calls separation of powers concerns. I'm going to come to that. What that will mean is that on the 30th of June, or the 1st of July, all 178,000 people and their children will no longer have a lawful basis to be in this country. They will be at risk of arrest, of deportation. They will no longer be able to work. They will no longer be able to use their bank accounts. They will no longer be able to attend schools. They will no longer be able to do all of these things, even though the minister's decision has been reviewed and set aside. Now that could never be a just and equitable order. And let me say, let's assume that in 2 months' time, in August, the minister makes a decision, oh, actually, I should have extended the ZEP. Well, then what are these people meant to have done for the 2 months in between? For July and August, they will have been living as illegal foreigners without being able to work, get educated, go to school, medical treatment, all of those things. So all that this order does is it says, while the minister decides, we will protect the status quo. Now, our learned friends seek to suggest that that is somehow inappropriate or impermissible. I'm not sure whether they say it's beyond the court's powers or inappropriate, but either of those submissions is no good. And could I take you back to the note for oral argument where we address this in the last section of the note? It is at page 060-28. Paragraphs 80 and following. And you will see that we make the point that there's no dispute about the first and second categories of relief, but that what they say is that the order, prayer 4, is effectively a substitution order. But it's not a substitution order, because what they overlook is that Paja, if Paja is applicable, draws a clear distinction between substitution orders in section 8.1e2 and temporary relief in section 8.1e. So what Paja says is that you can have a substitution order or you can have temporary relief. Just give me a moment. And what Paja says is that it says that you may only grant substitution orders in exceptional circumstances. Just getting Paja, if you would give me one moment. I thought I had it in front of me. Here we go. What Paja says is that there's a typo in that. I'm sorry. Substitution orders are 8.1c2, not 8.1e2. Paja says you can grant a substitution order in exceptional cases under 8.1c2. But under 8.1c, it says you can grant temporary interdict or other temporary relief. And that is what is sought, is it's merely temporary relief pending the decision on remittal. And there's no requirement of exceptional circumstances there, and for very good reason, because this court would not be finding that the ZEP program has to remain in place indefinitely. It would not be finding even that it has to remain in place for 3 years, and it would not be directing that. All it would be saying is that the process by which the decision was taken was invalid. We set aside the decision and we preserve the status quo while the minister gets another bite at the cherry. And that is hardly remarkable. That is what the courts do all the time when they grant interim orders of constitutional invalidity. In fact, it's demonstrated by the All Pay 2 and Black Sash cases, which we rely on, and which our learned friends seek to distinguish, but which, with respect, they don't do successfully. In All Pay 2, what had happened was that a tender award to cash paymasters had been set aside. But the debate was, well, who's going to deliver the pension? And the court directed that a fresh tender process take place. And the question was, who's going to deliver the social grants in the meantime? And so the court granted a status quo order which says, pending the decision of the new tender, it will continue to be CPS. And then in CPS, in Black Sash, the court did the same, and the court extended it even further, even by making a contract for the parties in substance. Now, what those cases demonstrate is the breadth of this court's power under section 172 1B of the Constitution and section 8 of Paja to grant any order that is just and equitable. And we have in our heads and in our note made the point to you that our courts have explained the breadth of the order. It's actually in the heads, not in the note, but in the heads, paragraph 225, the page is 020-88. We have quoted the decisions in Corruption Watch and Imwelasi to say that the Constitutional Court has emphasized that the phrase any order or any just and equitable order is, quote, as wide as it sounds, serving as an injunction to, quote, do practical justice as best and as humbly as the circumstances demand. And the court has said again and again and again that it has a broad remedial discretion to forge substance above form when it comes to a just and equitable order. So this is plainly within this court's powers, plainly. And it is plainly appropriate. And if our learned friends seriously suggest on behalf of the minister that it is not appropriate, we ask them rhetorically to address this question. If prayers 1, 2, and 3 are granted, and the matter is remitted to the minister on the 20th of June, for example, and the minister takes 3 months to take a decision, what do our learned friends suggest should happen to the 178,000 people for the months of July, August, and September while the minister makes a decision? What do they suggest those people should do? Do they suggest they should be deported? Do they suggest they should leave the country? Do they suggest they should no longer work and go to school? Because that is the consequence of not granting prayer 4. And with respect, there can be no answer. So we are not asking this court to direct the way forward. We are asking this court to fashion an interim remedy, which seems to us, with respect, obviously appropriate. And if our learned friends on instruction from the minister say that on the 1st of July, these people should now be deported and arrested, then with respect, they should say so expressly. And if they're not prepared to say so, they should indicate what order they suggest instead of prayer 4. That leaves one last point, and that is the point about the separation of powers. And of course, every government minister and every government agency who wants to resist remedy raises the separation of powers and says this breaches separation of powers. But for 2 reasons, that point is no good. Firstly, it doesn't breach the separation of powers because all it is doing is preserving the status quo pending the determination by the minister of the decision that is remitted to it. I can understand an argument about separation of powers if the court was directing that it remained in place indefinitely. That's not what the court's doing. I could understand if the court was directing that there be a path to citizenship. That's not what the court's doing. The court is just being asked to fashion an interim remedy. So the point about separation of powers, there is no separation of powers concern. But even if there was, and this is the second point, and it's at paragraph 83.1, where invalid and unconstitutional action has been identified, the Concord said in Imwelasi, the bogeyman of separation of powers concerns should not cause courts to shirk from their constitutional responsibility to grant just and equitable relief. That's what the court said in Imwelasi. Justice Collis repeated it in the ground-up case, the groundwork case. And the last point is, my client is not asking the court to fashion some new regime. All the court is saying is, Minister, you previously extended by 12 months to give people a chance to get their house in order. Then you extended by 6 months. You should now effectively extend again while you take your decision. That's the only effect of the order. And so that is hardly a separation of powers concern. Lastly, going back to the draft order, the draft order says the following. Paragraph 5, that the first respondent and other parties opposing the application are directed to pay the costs, including the costs of 3 counsel, We've asked for the costs of 3 counsel. We leave in the hands of the court whether 3 counsel or 2 counsel is appropriate. But it has been a massive case, as you are aware. And of course, although it's not determinative, I note that the minister has 4 counsel on brief. But we leave the debate about 2 counsel and 3 counsel in the court's hands. As the court will know from our heads, we all appear pro bono in this matter, and any costs would be recovered on a contingency basis in that regard. Justice Collis, members of the court, unless there are other questions at this stage, those are our submissions. I'm not going to deal with the truckers further for the reason I've given. I'll deal with them once we've heard them insofar as is necessary.
Yeah, all right, thank you. I don't have anything else. Judge Malindi?
Thank you very much, my sister. Mr. Butlander, maybe for consideration in reply, and also depending on how Mr. Jamie deals with this, if the court is with you on prayers 1, 2, 3, and the minister is very quick in dealing with prayer 4, that may have an impact on the rights that you have addressed us on. Will it be appropriate for a court to dictate a period within which the decision may not be implemented so that the impact on those rights is not as severe as you addressed us earlier?
Judge Malindi, my lord, I'm very grateful for the question, and it is a difficulty that occurred to me. I had presumed that a minister acting in good faith would no doubt allow an implementation period for any further decision, but with respect, it would be appropriate for the court to do so. So the court could simply say that the interim regime would last pending the first respondent's further decision, and perhaps for a period of 3 months thereafter, which would simply allow everyone to consider their position and act accordingly. So I will give it some more thought before reply, but my instinct is that that would be an appropriate order to make. Because of course, it's not simply about whether the decision is taken quickly. It's even if the decision is taken slowly. Let's say that the decision takes 5 months, and on the 1st of November, the minister announces, I'm now terminating from the 2nd of November. What are people meant to do? So it seems to me appropriate with respect. And I would expect if the minister is serious about people's rights, there would be no difficulty in saying that there would be a period of at least 3 months following any decision, which would allow parties, if needs be, to take appropriate action. So with respect, I welcome the question, and I'll hear what my learned friend, Mr. Jamie, says.
No, thanks. I have no further questions.
Okay, thank you, Mr. Butlander.
Thank you, my lady.
Thank you for keeping to your time allocated also.
Thank you.
Mr. Simmons?
Thank you, Milady. Milady, the court will have seen from the papers filed of record and the heads of argument of my client that we seek identical relief to that of HSF. We seek this both in the sense of what we do hope to obtain from this matter, but also in what we do not seek to obtain. As Advocate Butlander has pointed out, this is not a case in which we seek to obtain a final or permanent outcome regarding the permanent rights of the ZEP holders in South Africa, despite certain suggestions otherwise in the papers of the respondents. We seek only a simple, we would submit, straightforward case primarily concerning this notion of procedural fairness and procedural rationality. Now, I, of course, have the benefit of following after Advocate Butlander and bearing in mind your ladyship's warning about time and how much time we all have to complete this hearing. I do not want to repeat those aspects which she has touched upon. Okay. It is my intention, subject to the guidance of the court, therefore, to deal primarily with the reasons given by the minister for his decision. So those would be factors such as the situation in Zimbabwe, the impact on the South African asylum and immigration systems, the purported misconduct of ZEP holders, and the impact on the unemployment rate in South Africa. And I am going to get to and I will deal insofar as possible with my time with the truckers application. That being said, I must at the outset make points concerning this broad question of procedural fairness and rationality for two reasons. The first is, of course, there are aspects of that point which particularly concern my client, Quamsa. The second, however, is because, as I believe Advocate Butlander was at pains to point out, that is the case that cries out to be answered with respect. At the core of this case is the notion that these 180,000 people who've lived here lawfully for over a decade should be afforded some opportunity to have a voice in the decision as to whether their stay in this country should be terminated or the basis of their stay in this country should be terminated. And that simple case, milady, we submit has not been answered by the respondents. Now, bearing that in mind, I must acknowledge up front that many of the points to which I'm going to touch, the grounds of review about what's happening in Zimbabwe and so on, the court may not need, quite frankly, to go there. I wish to acknowledge that up front, because there is this case about procedure and about fairness and about rationality which is being made. But nonetheless, it is important that all aspects of the case raised by my client and by the respondents be addressed, and therefore that's the structure I intend to follow. Lady, in answer to what we would submit, this overall case concerning procedural rationality, the respondents have advanced, well, initially 2 and now 3 broad lines of defense. The first was that the ZEP expired by a fluxion of time. The second was the somewhat contradictory notion that the minister hasn't actually made a final decision and the ZEP is therefore potentially to be extended going into the future. And the third was the point raised in the most recent set of submissions by the department that perhaps there's that the decision of the minister is a form of executive action and therefore doesn't attract any form of fairness or rationality. On that final point, the question of whether or not this decision, whatever we wish to call it, this termination of the ZEP or slow transition away from it, is executive action, we make common cause with HSF and with the submissions made by Advocate Butlander. I'm not going to repeat those, subject to the court's guidance. On the question of whether or not the minister has made some form of a final decision, or as is suggested in part here and there by the respondents, whether in fact he's open to receiving further submissions from the parties. Again, we make common cause with the points made by Advocate Butlander, but we must add certain submissions. My client and the deponent, the chairperson of Quamsa, has gone on record to say that the stance expressed in the Director General's affidavits, that in fact the minister's mind is open and that he is willing to consider further extensions of the ZEP, and there has not been a final decision to terminate the ZEP, took him completely by surprise. In fact, he went on record to say that every stakeholder in the refugee, asylum seeker and migrant community of which I am aware held the view, based on the respondents' public statements, that the ZEP was effectively being terminated at the end of 2021. This affidavit was deposed to before that 6-month extension, Justice. And I'm not going to take the court to it because it's just a short quote, but that would be found at 23-14, paragraph 35 of the founding affidavit. The point I'm making, lady, is not merely that there is a change of stance in the Director General's affidavits. It's that even if the minister did have some willingness to change his mind about his decision concerning the ZEP, that openness, that willingness was not communicated to the refugee and migrant and ZEP community. No one looked at these documents, these public statements, and read them as saying, I am considering what to do. I am open and willing to extend the ZEP. And that can be seen from any one of the public statements made by the minister at the time. In our heads of argument, we have advanced two propositions, well, a number of propositions, but two in particular. The first proposition was that decision makers are bound by the reasons they give at the time of making a decision. And there's a range of authorities in support of that, and I believe Advocate Butler even referred the court to it. You can find those authorities and our heads of argument at 24-10 of case lines. It's in footnote 9. The second proposition of relevance is that no person may make an affidavit on behalf of another. And this, of course, begs the question of the Director General's, we call it retrofitting of the stance adopted by the minister. The point has been made that the minister cannot do so, but it is striking that this is a matter, given its importance, given the prominence of this matter with 180,000 people's lives at stake, that there is no affidavit from the minister. In defending this absence, in their heads of argument, the respondents have relied on two cases, my lady, and in their heads of argument, these cases can be found at 28-115. It's paragraph 36 of their heads of argument. There are two cases. The first is the South African Poultry Association versus Minister of Agriculture and others. And the second is the President of the Republic of South Africa and others versus the Mail and Guardian Media Limited. And just to touch briefly on those, neither of those assist the respondents in suggesting that the DG can now step forward and add or supplement or amend the submissions made by the decision made and the reasons given by the minister. The first case, the South African Poultry Association, concerns very different facts. In that matter, milady, there was a decision about essentially ways of preserving chicken for food safety concerns and so on. And there was an exhaustive process with thousands of pages placed before the minister. And the debate was over whether or not the minister properly took those thousands of pages into account in reaching his decision. And that is obviously radically different to this matter. In this matter, the core concern is that there hasn't been anything placed before the minister. We have important entities like my client who have not been afforded a fair opportunity to make their case. The second case, milady, the Mail and Guardian case, that concerns a case, it's also distinguishable facts and does not assist the respondents. That concerns a case in which senior judges were sent to Zimbabwe to compile a report on the lawfulness and fairness of that election. And the contents of that report, the government held were confidential, privileged in some sense, and the Mail and Guardian newspapers sought to obtain it. And in defending against the Mail and Guardian's application to obtain this document under PIA, the government relied upon affidavits from various senior officials. The senior officials in question had the benefit there of having read the report. So when they made comments on it, and they made very vague comments in the context of that particular case, because they submitted that they were constrained to not divulge through their comments the confidential nature of the findings made. But the point was, in the course of their duties as senior officials, they had sight of this document, which was the key document at hand. Here, we have a very different situation. In this matter, the minister made repeatedly public statements as to the decision that he'd made and the reasons as to why he had made them. And it's perhaps worth emphasizing that the minister didn't just rubber stamp or repeat the submissions made to him by the Director General. The Director General's submissions to the minister can be found, it's FA 8 to the founding papers of HSF. It's at 1-96. I'm going to direct the court to it. Hopefully the court will get it.
No, what's the reference? 1-96.
1-96 is there no?
Nothing pops up. Sorry.
Nothing pops up. Well, if the court would be so kind as to find 1-96, I'll try direct page again.
So there's no digit before the 1.
001, sorry, -96.
Thank you.
Justice Collins. Okay.
Okay, there we are. FA8.
FA8, that's the one. This is the submission made by the Director General to the Minister. And you can see if the court scrolls through it, the DG, the Director General, then sets out the facts as to what is proposed. And at the bottom of page 00197, he sets out his reasons for recommending the termination of the ZEP regime. And 4-1 is that the exemptions to the Zimbabwean nationals are a temporary measure. And this wording, you will see in this paragraph, milady, is almost word for word what is upheld in the decisions and the letters of the minister. I'll take the court there too in a second. And the second paragraph, 4.2, also almost identical. 4.3, identical. But around about 4.5, the Director General gives reasons in favor of his decision, which you will not find in the reasoning of the minister. So that's at 4.5, you'll see reference there to the Zimbabwean nationals migrating to other visas provided for in the Immigration Act. 4.6, reference to an alleged outcry from citizens that the exemption regime granted to Zimbabwean nationals strains the shrinking budget of the department. These considerations, the minister did not include in his reasoning. And I emphasize that because the point is that the minister, the Director General cannot simply say, my reasons and my thinking and my approach to this issue is that of the minister, because the facts are when you compare his submission to that of the minister, you will see that there are differences. The minister's public statement, milady, is FA 13. Well, there's a range of them, milady, but the one that was published in the Star on 7 January 2022 is perhaps the most public of the reasons. I'm going to again try to direct the court to that page.
The page reference on case lines?
It's 001-122. It's FA 13.
Thank you.
Milady, and if the court has regard to this notice, and you'll see there in the middle of that page a statement, the decision of the minister was taken due to inter alia the following reasons. And you'll see there, those are the paragraphs which I said were quoted almost word for word from the DG statement. And you will see there that the minister has not repeated those latter paragraphs to which I directed the court's attention. While we are here, in fact, milady, I'm going to refer the court to one more page, which repeats these reasons. And that is the letter that the minister arranged to send to all ZEP holders. It's at 010-145. I promise this should be the last of the references I'll have to take the court to for a while.
That's fine.
Could you repeat the reference, Mr. Simmons?
010-145. I have, on case lines, I have issued a request to direct it, and it says directing please wait. I'm afraid I'm not sure why case lines is not being helpful.
I don't know either. But
If
we
the
are on
court-
the page. We are on the page. Are you there, Judge Malinde?
I am. Thank you, my sister.
And I see Justice Morton nodding,
Nodding.
so I'll
Okay.
proceed. Justice, this is the letter which the minister directed to be sent to all the persons who held ZEP. So if you were one of the 178,000 persons who resided here for 13 or more years, this is what you would have received. And again, if one scrolls down to the second page of that paragraph 7, you'll see there again, identical reasoning. But it is worth stressing the actual language used at the outset of this letter. It is headed non-extension of exemptions in terms of section 31(2)(d). 31(2)(d), specifically subsection D, is the statutory power to withdraw an exemption. Not to grant, not to extend, it is the power to withdraw. And if you see in paragraph 2 there, it's stated, the Minister of Home Affairs has exercised, past tense, his powers in terms of section 31(2)(d not to extend the exemption granted to you in terms of this section. In paragraph 3, in order to avoid unnecessary prejudice, the Minister has also imposed a condition giving you a period of 12 months. And then the important phrase, in order to apply for one or more of the visas provided for in the Immigration Act. Not the ZEP, not a continuation of the ZEP, but a visa under the Immigration Act. And the same message is repeated in paragraph 5. So I emphasize this wording, milady, to reinforce the point which Advocate Badanda has made, which is that if one looks just at the wording of the minister at a very basic level, this is what he said, this is what he wrote to the people who are affected by this. This is his wording, and there's not a single affidavit from him refining or varying or explaining or expanding upon this reasoning. And if one looks at that, nothing in that suggests that he has anything other, he's done anything other than make a decision. He's made a decision to terminate the ZEP, and the 12 months or so that he's afforded, that was obviously extended to 18 months later on, was not because there was some uncertainty in the minister's mind as to the ultimate termination of the ZEP. It was a transition period to allow people to move on to other visas. That is, in terms, what the minister has said. And I could expand on this, milady. There was the engagement with the Scalabrini office, where the minister wrote back and said this in terms as well. There are other documents where the minister said this. But Advocate Badanda has touched on that, and I'm going to risk unduly repeating his points if I do not stress. Do not move on. The point is simply that, is to repeat that made by COMSA. When the ordinary people on the ground got these letters, even if the minister did perhaps have an open mind and a willingness to consider things, already at this stage there's an unfairness because people are not being informed of their rights and opportunities to change the minister's mind. They are not being told, I have an open mind, I may extend the ZEP, let me know your thoughts. They're being told in terms, a decision has been made, and they're being warned to get on with their lives. And the fact that there is at the end of this letter an invitation to submit vague representations to the Deputy Director General does not change that. There's the submission. A point that is specifically made about my client is that even if there has been a fair process, and perhaps that process excluded COMSA, but COMSA is not better placed, is the wording used, than ZEP holders themselves. And so if these letters were sent to ZEP holders, then there's simply no fair or rational reason to include COMSA or entities such as COMSA. And with respect, we would submit that that is incorrect. COMSA as the consortium of refugee migrant service providers in South Africa, is not the only refugee and migrant service entity or network in this country, but it is, we would submit, amongst the most prominent. If one looks at the names of individuals concerned, and there's no need to take the court there, but it is included in the founding affidavit. There are names with which the court will no doubt be familiar with: the Black Sash, Lawyers for Human Rights, the UCT Refugee Rights Center, the Scalabrini Center, which is now litigated several times over refugee matters, the African Center for Migration Society. All of these individuals and entities and organizations have a rare and unique expertise. And so the question as to why would it be either fair or even rational to include them is answered because of their expertise. They have a particular perspective and experience and institutional knowledge of these matters, which we would submit it is not only fair to include and sensible to include, but it is indeed irrational not to include. And this was touched on in the Scalabrini case, to which Advocate Butler has taken the court. That was the 2013 judgment of the Supreme Court of Appeal, which dealt with the closure of the refugee office in Cape Town. And again, I don't want to repeat those submissions, but in that case, even though PAJA was held not to apply, it was stated that it is irrational not to include entities such as Scalabrini, which is a member of COMSA, because of their particular expertise. Now, in response to this, the department has made 2 points. The first point is that Scalabrini was included. There was an engagement with Scalabrini, and if Scalabrini was included, then COMSA has nothing to complain about. Well, the answer to that is twofold. Firstly, Scalabrini is only one organization within COMSA. There's a wide variety of others: Lawyers for Human Rights, the University of Witwatersrand Refugee Clinic, many others who have their own individual contributions to make. The second point, though, is that Scalabrini wasn't actually consulted. The minister took his decision, and Scalabrini then wrote to the minister in that series of engagements that the court has already been taken to by Advocate Butler. And the minister told them, my mind is made up and there is no scope to change my decision. So there was, in fact, no proper consultation with Scalabrini. I think the other point made by the department was that I think Advocate Butler has touched on, is that there should be a prior hearing. And he quoted for the court, and he took the court to various dicta from the Hoekstra textbook, and he had a discussion with Justice Motta about the ramifications of that finding, the underlying principle that there should be a prior hearing. We have in fact quoted Hoekstra in our heads of arguments, so I'm not going to repeat that, but I must simply state again, we agree with these submissions of Advocate Butler on that score. And we also concur with the finding and the conclusion that PAJA applies to this matter, but even if PAJA did not, that the principle of rationality and the principle of legality would apply. And under that principle, there should have been a hearing, which included my client, and there was not. So, milady, there is the last, let me just take my time. We would submit that bearing those principles in mind, there is no answer to the fundamental case made concerning a lack of procedural fairness and a lack of rationality. The facts are quite simple. In the wording of the minister himself, a decision was made. That decision undoubtedly had an adverse, very adverse and serious impact on 180,000 people who've lived here lawfully.
Just one question, Counsel. Are you saying all these organizations, I think if my calculation is correct, it runs into almost 30 or so of them should have been informed?
we would submit that they could be informed, and they should have been informed because they do all have expertise. But just to be clear, Justice Morton, we're not saying that everyone had to be written to individually and given a letter, and if the minister failed to think of all of the 30 people on the list, that singular omission would have resulted in this process being unfair. It is possible for parties to be invited to participate fairly and reasonably prior to decision being made by public invitations to comment. That is typical.
Perhaps public hearings even.
Public hearings, indeed. And a good example would have been, for example, if the court will recall, I took you to that notice in the Star, where the minister said, these are my reasons. Something like that could have been done prior to this decision being made. We would have said, I, as the minister, am considering making this decision for these reasons. I haven't made up my mind, and within the next month or 2 months, I invite parties to make representations. And anyone who wishes to do so can do so. That would be a fair process. And there would also, we would submit, be a rational process under the principle of legality. There was a discussion, Justice Morton, between yourself and Advocate Badanda about the fact that rationality is a more flexible standard than procedural fairness, with which we, of course, agree. But that would be one of the ways in which you could have flexibility while still achieving the core notion. And the core notion is you're making an enormous decision here, an enormous decision that affects the rights of many, many people, their children, their lives, their homes, and all of that. And there must be some rational, fair way in which to include them. It doesn't have to be perfect, but it should be fundamentally there before the decision is made, and it wasn't. I think I must move on to the 4 grounds of review. The first ground, Justices, was the suggestion that the situation in Zimbabwe has now improved. And with this point, in the HSF papers, Advocate Badanda didn't deal with it, but in the papers in HSF, the point was made that in fact the economy of Zimbabwe, quite simply and factually, has not improved. They cited a wide variety of dubious statistics. I'm trying to find them. I don't think I need to take the court there, but just to give the court the flavor of the kinds of concerns. HSF pointed out.
Advocate Simmons, I just want to cross-reference to the rest of the bench. In his head, he deals with this from paragraph 62 onwards, and that is on 024-26.
I'm indebted.
Thank you.
I'm indebted. Justice, HSF makes the point that, and this is in their founding affidavit, in 2019, even before the COVID-19 pandemic, Zimbabwe plunged into a recession, which saw its economy contract by 8.1%, the greatest economic decline in over a decade. The recession saw Zimbabwe's inflation rate increase to an average of 255% in 2019 and 557% in 2020. In 2021, the annual average inflation stood at 98.5%. Poverty, then further on in this funding affidavit, poverty rates in Zimbabwe exhibit an alarming upward trend. In 2009, more than 70% of Zimbabweans lived under the national poverty line, with 22.8% living in extreme poverty. But by 2020, that 22.8% had increased to 49%. So these are simple. There is some debate, which I'm going to take the court to in a second, over the exact details of these figures. But the picture being painted here is of an economy that is still so drastically in crisis that the minor improvements to which the respondents attempt to point do not change the fundamental picture. There has not been a substantial improvement in the Zimbabwean economy, and I would submit that this is a matter of public knowledge and record. Similarly, there has not been an improvement in the political situation in Zimbabwe. Now, politically, the initial crisis in Zimbabwe in 2008 was triggered not merely by hyperinflation, but by violence and instability linked to the 2008-2009 elections in Zimbabwe. So there's a tight connection between the elections and the violence and the instability. And this is relevant, my client makes the point, because later this year, in fact, there's going to be another set of elections in Zimbabwe. And we have quoted the, if the court would, in my heads, I think the court was referred at 024 -27, paragraph 67 of my heads. We quote only two of the sources. So there's a variety in the papers, as annexures, as in the affidavits, but we quote only two. The Zimbabwe Lawyers for Human Rights issued a report titled "Human Rights Defenders Under Threat: An Analysis of the Shrinking Civic Space in Zimbabwe," and it concluded, unfortunately, in this report's analysis of the period between 2018 and 2021, instead of an opening of civic space, the ZLHR has documented thousands of cases of human rights defenders being subjected to gross violations of their rights, including through unlawful killings, torture, beatings, arbitrary arrest and detention, death threats, harassment, and defamation. These acts have been conducted with impunity, and there's even more information, but I won't quote all of that. On the following page of my heads, 024-29, there's a quote from the 2021 State of Peace report by the Zimbabwean Human Rights Association. And they say, elections in Zimbabwe have become a nightmare. They come with the assurance of violence, but no development. Unemployed youths are deployed to terrorize communities and harass NGOs that are deemed to be interfering with the political objectives of the elites. Our peace activists say each time an election date is announced, fear grips the communities. This is not how things must be. And the quote goes on along those lines. In response to these submissions, and concerning particularly events and circumstances in 2023 in Zimbabwe, there is, with respect, nothing provided in countervailing evidence by the Department of Home Affairs. In their heads of argument, I'll take the court there in a second. So their heads can be found in, the paragraph would be 028-125. In their heads of argument and with reference to their affidavits, of course, their references to various findings made in 2013 and 2018. Those we dispute, but since those are now almost half a decade or a decade old, I'm not going to engage with them. But concerning the claims of what is the situation now? To what position are we returning these people in 2023? The only evidence they can give is a statement by the South African Minister of International Relations and Cooperation concerning a bilateral commission between South Africa and Zimbabwe. That quote can be seen, as I've said, at 028-125, and it continues over the following page. It refers to, for example, the fourth line violence that erupted following the disputing of election results, this is in 2018, by the leader of the then MDCT, and the subsequent government response is well documented. President Mnangagwa established a commission of inquiry on the post-election violence, which was chaired by former President Kgalema Motlanthe. The recommendations were released in public, which in South Africa's view was a signal of commitment by the Zimbabwe government to their implementation. And then it goes on to say, to quote from various instruments. However, the point is made, and it's not disputed, by HSF in their founding papers, that the findings made by that Commission of Inquiry were never followed up on. There was no justice for those affected by the electoral violence in 2018. And there is nothing, simply nothing, about what the situation is on the ground in 2023. And so to conclude this point, because it's a point I must make when I come to my second round of review, it's not merely that we submit that the minister was wrong on the facts in saying that Zimbabwe has now moved past its crisis, but it's that the minister did so without providing any evidence, any realistic evidence of sources or authorities or articles or credible reports on which he bases that finding. It is possible to imagine, for example, that my client would have brought this case and we would have said, we dispute what you've said about Zimbabwe. And in the answering affidavit, the minister would have said, well, actually, here's my evidence. Here's this report. Here's this article. We've spoken to these people about the situation in 2023. These are these credible persons. But there is none of that with respect. It's simply not provided there. So on the one hand, the point is that the minister has erred on the facts. But the more subtle and important point, perhaps, is that the minister has not applied his mind correctly to these facts. There is simply not sufficient research into these matters which call for proper consideration and debate. And that is, we would submit, because of the failures to conduct hearings, to invite comment. If the minister had complied with the basic duty to allow people to make submissions, all of these details and facts and disputes would have been in place before him. Perhaps he would have agreed, perhaps he would have found on the evidence that he didn't agree. But either way, they would have been brought to his attention and he would have had an opportunity to engage with them. But he didn't, and that has led to these failures. Moving on to the second point, milady, that is the concern about the impact on South Africa's asylum immigration systems. And the court will recall here that the nub of the point made was that South Africa's, well, the Department of Home Affairs generally, had been impoverished by the impact of the COVID-19 pandemic. That the budgets and so forth, which they had hoped to use to further the immigration and refugee system, had been forced to be downgraded because of the simple lack of funds. And that was used as a explanation for why the ZEP had to be withdrawn. And again, milady, there aren't disputes over perhaps whether the ZEP pays for itself, or could we perhaps have charged the ZEP holders a bit more money to make the system a bit more profitable. There are these minor quibbles which are dealt with on the papers, and I'm not going to take the court through all of them. But the true irrationality we would submit, and I say not merely unreasonableness here, but I do say irrationality, is that the ZEP was conceived and designed as a cost-saving mechanism. It was designed when in 2008, 2009, there was this massive influx of hundreds of thousands of Zimbabweans, and the systems of the department could not function, and therefore they instituted the ZEP. So to say that because of a lack of funds, we're going to drop cost-saving mechanisms, quite simply, we would submit, is irrational. And there is with respect, no particular answer to this concern. In their heads of argument, the Department of Home Affairs does say that just as an example, I'm quoting from paragraph 84. This is at 028-128. They say it's clear that the introduction of the exemption regime did not significantly decrease pressure on the asylum system or stem the flow of illegal migration to South Africa. And that, we don't accept that is true, but even if that is true, that misses the point. It may not have significantly decreased pressure, but it did something. That's why it was introduced. That's why it was allowed to exist continuously for the past 13, 14 years. And if you are, as the minister himself says, in a situation where the department is simply pressed for funds, then every mechanism to reduce pressure on the system is a beneficial one. The suggestion in the papers made by the department are that very few of these individuals thus far, these ZDP holders, have thus far applied for waivers and other documents in South Africa. Those figures are not entirely reliable because they are at this stage quite outdated. They were filed back in I think it was September of last year. And of course, there has been a 6-month extension since then, specifically because there was anticipated there'd be an influx of ZDP applications. But that being said, even if only approximately 10% of ZDP holders attempt to enter the asylum system, that would double the number of asylum seekers that came to South Africa in 2018. I refer to 2018 because later figures were impacted by the COVID-19 pandemic, and therefore they're unreliable. But there is evidence on record, and I can take the court there, that in 2018, approximately 18,000 asylum seekers applied for asylum in South Africa. That is a mere 10% of the numbers of persons affected by the ZDP situation. So even if the minister is right, and 90% of these people are going home, he is still doubling the demands placed upon a system which, in his own words, has been overwhelmed, which we submit is irrational. There are further points made, notably suggestions that subsequent developments have increased the funds available to the department. There's reference to a 143 million rand provided by the United Nations High Commissioner for Refugees. But all of these arguments that go to saying that, in fact, the department may have funds, they don't assist the respondents in this case because the minister's decision was based on lack of funds. If the situation has changed and the department now has abundant funds, it's still fatally problematic for the department because now the decision made by the minister is based on facts which no longer exist. For concerns of time, I would submit I'm going to move on to the third and the fourth grounds, subject to guidance by the court, of course. Both of these points, the first point being the impact of the ZDP holders on the unemployment rate, and the second being the purported misconduct of ZDP holders, require me to ask the court once again to go back to either the letter of the minister sent to ZDP holders or to the public statement in the Star. I'm going to try and direct the court to the Star advertisement. There should be a direction via case lines.
We don't have it. Just give us the reference.
Certainly. The Star is at 001-122.
FA13.
FA13, that's the one. The court has been there before, I realize this. But I wish to be very clear about the wording and the context of these reasons. So I'm referring the court to 7.3 and 7.4. 7.3 saying, according to Statistics SA, South Africa, The quarterly labor force quarter 2, South Africa's unemployment rate increased by 1.8, bringing the overall rate to 34%. This is the largest recorded since the start of this labor force summary in 2008. And secondly, the DHA came to realize that some of the Zimbabwean exemptions holders were violating the conditions in that about 1,900 were somehow able to apply for waivers in terms of the Immigration Act. Their applications were rejected. And the submission that COMSA makes is that the minister relied upon these reasons, and these reasons are with respect unreasonable and or incorrect. And the reason I'm dealing with them together, milady, and the reason I'm stressing the wording of these paragraphs is because the Director General does not defend these reasons. If one, and I wish to be very careful in my language here, because I, perhaps Advocate Jamie SC will correct me in due course when he addresses us, but in their affidavits and in their heads of argument, they say, in the answering affidavit is pointed out that there was no reliance on or perpetuation of the belief that immigrants take jobs from South Africans or that immigrants are enriching themselves to the detriments of South Africans. And they say that we are wrong to say that the minister relied upon these considerations. And with respect, and the reason I'm pausing here is I just simply cannot understand how that could be correct. If one looks at this decision, it says in paragraph 7, the decision of the minister was taken to, comma, inter alia, comma, the following reasons, and there are 4 reasons listed. And there's no doubt he took into account 7.1 and 7.2. The department deals with those as best that they can. So then what is the minister possibly saying in paragraph 7.3 and 7.4, other than that the unemployment rate of South Africa is worsened by the ZEP regime? And because we obviously want the unemployment rate to go down, and it's a huge problem in this country, because of that, the minister was constrained to end the ZEP. I would submit no other reasonable way to read this in context.
So it's a case of COMSA here that what is set out in 7.3 as well as 7.4 is in fact part of the reasons that inform the minister in the decision that he ultimately took.
Indeed, lady. And again, the striking thing about this is that the minister took these reasons. We, as a COMSA, we attacked these reasons in our founding papers. We said, whatever we said, we attacked them. The minister has not filed an affidavit, as has been so often repeated before you. And the Director General has not sought to defend these reasons in any way that I can make sense of before this court. In that circumstance, this is, with respect, fatal. Because the fact is the minister made a decision, he relied on certain reasons, the reasons have been attacked, and they have not been defended. Evidence has been given before this court which has not been answered. In that circumstance, with respect, the decision of the minister was made without good cause. It need only be that one of the material grounds relied upon by the minister is defective for the decision as a whole to be set aside. In this circumstance, we have 2. I am constrained to conclude that the minister, or I should say the DG, did not defend these reasons because they are indefensible. The first ground effectively implies that foreigners take jobs. Quite correctly, in his answering affidavit, the Director General does not try to uphold such a position, which does rely upon very unfortunate and problematic and serious stereotypes about foreigners in South Africa. I am aware in their affidavits and in their heads, they do take issue with some of the finer points, some of the evidence submitted by COMSA, and some of the reports that we attach reports from the World Bank indicating that foreigners are in fact a positive net benefit to the South African economy. And they quibble with certain of the overall evidence there. But again, there's nothing suggesting that there's any evidence to back up the stereotype which we see present here, that foreigners take jobs. So I don't want the court, I'm not asking the court here to make pronouncements of economic policy, to investigate at length questions of how do foreigners generally interact with the economy at all levels and in all ways. That's not the point. The point is that the minister didn't apply his mind properly to this question. There is no evidence supporting the assumption which you see here. There's no research, there's no articles, there's no expertise from any person who's considered these questions. And I focused on the unemployment, but let's consider for a second the second aspect there. The DHA came to realize that some of the Zimbabwean exemption holders were violating their conditions and that they were somehow able to apply for waivers, and these applications were rejected. Well, firstly, this is only 1,900 people out of approximately 180,000. Secondly, I don't believe it is a violation of conditions to apply for waivers. Anyone can apply. It's a statutory process. You have a right to apply, and if you have a deserving case, you get granted, but if you don't, you get rejected. So there's nothing here which is unlawful. And to suggest that the fate of 180,000 people could have been decided bearing in mind the supposed illegality is strikingly unreasonable, and indeed we would submit again irrational. So these grounds with respect are undefended because they are indefensible. And once the grounds on which the minister made his decision fall, that is with respect is the end of the matter, then the decision as a whole must fall. That would ordinarily take me, milady, to remedy. But Advocate Badenda has touched on remedy. I am trying to be swift, and I have nothing dramatic to add to him. And other than perhaps underlining the point which he did make, which is that some measure of interim relief or protection must follow on the declaration of invalidity which this court may choose to make. If it does not, all of these people will be placed in an invidious position. Their bank accounts frozen, their jobs in jeopardy, their homes in jeopardy. So a just and equitable remedy in terms of section 172(1)(b) must include the interim provisions suggested by HSF. And we make common cause with the draft order which they have handed up, or uploaded onto case lines. And we also, I bear in mind, there was a query raised by Justice Malindi and an answer given about a potential protected period. We also agree with Advocate Badenda's submissions on that point. I promised the court that I would then touch on the truckers application. Let me take 5 minutes, milady, and just briefly do that. We submit with respect that the application has no merit, and the core of that application appears to be a submission that the minister's powers under section 172(1) are constrained. They're constrained in that they can't be granted such exemptions.
Sorry, Mr. Summons, would it not be prudent for you to respond to that application once Council for Truckers has actually presented their case?
I have no difficulty with that, milady. I just felt that I had told you I would, so I should.
I think that's the route to follow, rather, because you're responding now, but they haven't presented their case yet. Remember, they are before this court as an intervening third respondent.
I have no difficulty, and I was certainly hopeful of finishing with enough time that the next council could present something meaningful to the court. So, subject to the court's guidance, I would be happy to conclude my submissions at this stage.
Right, let's find out. Judge Malindi?
I agree with your proposal that the truckers' case is better dealt with once they presented their case.
Yeah, thought so. Judge Mota?
Yes, that's logical.
All right, so you'll have an opportunity, in reply to deal with whatever argument they put up before the court.
As the court pleases, lady. In that circumstance, then those will be my submissions to the court.
Thank you. Thank you, Mr. Simmons. Let's just find out, Mr. Jamie.
Yes, Justice.
All right. Would you want to start your argument today already?
No, I was planning, well, depending on how long Mr. Mojapelo is, I understood the arrangement would be that all of the persons challenging the minister's decision would go first and then the respondents. So I expected, and I think he did as well.
No, that's fine. So you can go first then. Advocate Mojapelo can go first and then you'll respond.
If there's only a short while left, I would ask for some injury time. We've heard a lot today, so I would respectfully ask to begin the argument tomorrow so I can digest and just, try to make the response sort of more focused and narrow.
Yeah.
So to begin tomorrow morning rather than later this afternoon.
Okay, no, that's fine.
As the court pleases.
We can do it in that fashion then. Advocate Mojapelo, are you ready to present your argument?
Yes, as may please you, my lady. And
There was an indication given that you will take approximately an hour.
Yes, as the court pleases.
Slightly less than that now, but you can proceed now. And if you don't finish, we can give you an additional few minutes tomorrow morning.
Yes.
Thank you.
The truckers' case is quite simple, and it's a case that's supposed to be preached by all the parties. Our main emphasis is on the rule of law. The rule of law and the principle of legality. So our case is quite confined to the powers that the statute and the constitution gives to the minister, which will eventually affect what the other applicants are seeking this court to do. So we will briefly deal with the Home Affairs case, that's the minister's case, and deal extensively with what the Section 31(2)(b interpretation and application is supposed to be, and deal with the special circumstances, argument and requirement, and mostly we'll be dealing with what the so-called the situation in Zimbabwe. And we'll go back to deal with the issue with the interpretation of Section 31(2)(b) to find out or to convince this court that the minister does not have any powers to extend. That section does give the minister some powers to do something else, but the powers to extend are not found in there. The minister's case and the papers starts by giving us a history of the powers that the minister had in terms of the previous regime. For an example, they refer us to the 1913, 1927, and to the now repealed Aliens Control Act. Although these submissions might be useful, but we submit that now in this constitutional era, they should not even form part of the jurisprudence. Section 2, that is the rule of law of the Constitution, which the court is very familiar with, is worth repeating that the supremacy of the Constitution. This Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. So, inasmuch as the minister had those powers in terms of the previous legislations, which we will not make any submissions on, we submit that based on the supremacy of the Constitution, that history is not helpful at all. It belongs to the history books, not to the current jurisprudence.
Apologies, Mr. Mojapelo. Can you just cross-reference the court to your heads on case lines?
Oh.
Yeah, if you don't mind, because we are trying to follow the structure of your heads on case lines.
Yes, as it may please you, my lady, most of my arguments will not be following the heads of arguments as it is.
Mm-hmm.
Yes, it's pocket 58.
Thank you.
My junior will direct the court. Yes, it's pocket 59. 01. We operate under the pretense and the well-known principle that the court has dealt with our heads. We do not abandon any point. We persist with that point. But for the sake of time, we would like to finish today. Hence the slight deviation.
That's fine. Thank you.
Yes. I've dealt with the supremacy of the Constitution, and I've dealt with that and also prefaced the minister's case. The minister's case, before I deal with the minister's case, our biggest complaint is the following, that the minister, when he granted this exemption and he purported to be acting in terms of Section 32(1)(b), he did not have that power. We will deal extensively with this Section 32(1)(b). 31 or 32(1)(b), the common section that we are dealing with. 31(2)(b). Yes, my lady, I keep on fumbling on the section, but we know which section we are dealing with. It's 31 in brackets 2 in brackets B. Minister did not have the power to grant the exemption. He did not have the power. Now he proposed to extend. He does not have those powers. What the other applicants are seeking, we will submit, is an extension of this illegality, as the minister does not have the power. There is a criticism against our case in that we did not challenge the extension when they were, the exemption when they were initially granted, but it is common cause, and it was submitted during the application for exemption, that our intervention, that our coming into being, that is the trackers came into being on the 17th of November 2020.
Mean into existence?
Yes, they were incorporated, and I will refer the court to annexure in our intervention application. It's annexure A1, as soon as my junior finds it. The minister's case, or the minister's submissions to this court will be found mostly in those media statements that were issued previously. And those media statements are found in Annexure FA, mostly Annexure FA2 to the main application, by the Helen Suzman Foundation. My junior will direct the court to Annexure FA2, which is in 001-87. I will not read the whole thing, but the objectives were tabled as follows. That is the objective of the special dispensation to the Zimbabweans. To regularize Zimbabweans residing in South Africa illegally. And we will need to emphasize the word illegally when we come to the section. To cap the deportation of the Zimbabweans who were in South Africa illegally. And then to reduce pressure on the asylum seeker and the refugee regime, and to provide amnesty to Zimbabweans who obtain South African documents fraudulently. And the others were read in court this morning. That is, one of them this was a significant gesture of support and solidarity to our neighbors and country of Zimbabwe in response to a large number of Zimbabweans residing illegally in South Africa due to political and economic stability. I will not refer the court to many other instances, but those are what we found to be the reason why this scheme, this dispensation of the permits was put into place. In their answering affidavit to this application, they add the powers that the minister has, and they refer us, it will be 055-11. They add that the minister, on paragraph 20, which come the paragraphs that comes before that. Paragraph 20 on the minister's answering affidavit is that the minister's powers to grant exemptions are contained inter alia in section 31, read with regulation 28, regulation 29, and regulation 30 of the regulations promulgated under the Immigration Act. And this is the time now to deal with the section S, to find out whether these powers that the minister proposed to be acting upon are found in section 31. Section 31 starts by saying, 31(2) starts by saying, upon application, the minister may, under terms and conditions determined by him, and I go to B, grant a foreigner or a category of foreigner rights of permanent residence for a specified period or unspecified period when special circumstances exist which justify such a decision. And it goes on to say, provided that the minister may exclude one or more identified foreigners from such categories, and paragraph 2, for good reason, for good cause, withdraw such rights from a foreigner or a category of foreigners. When one has regard to this section, one will see that the jurisprudential grounds to be available for the minister to exercise his discretion can be summarized as follows. There must be an application, and 2, that application must be done by a foreigner. And the word foreigner is extremely important in this way, because, as we stated in our heads of argument, the Act clearly distinguishes between a foreigner and an illegal foreigner. A foreigner is an individual who is not a citizen, full stop. That is what the Act says. And the Act also, that is in section 1, the definition section. It says an illegal foreigner means a foreigner who is in the Republic in contravention of this act. So the drafters of this Immigration Act knew that when they drafted Section 31, that there will be illegal foreigners in South Africa, but they chose to exclude them from this definition of Section 31 2B. It says the minister may grant a foreigner or a category of foreigners. And it is our submission that an illegal foreigner or a foreigner without proper papers, that is the loose definition, is excluded from this exemption.
So sorry, can I just follow the argument? And there's somebody talking there. I don't know if it's coming from your side, Advocate Majapelo. I want to follow what you're saying. So you're saying the provisions of Section 31, 31(2)(b) is only applicable to foreigners, not illegal foreigners. Is that your argument?
Yes, as the court pleases.
Okay.
As the court pleases. Yes. And I'll confirm the noise was not coming from my side.
No, that's fine. I was just saying somebody's talking and also stirring a nice cup of tea or something, which we all wish to have, but if they can just switch off their microphone while they're doing that.
As the court pleases.
Thank you.
Yes. So
yes, thank you. May proceed.
As the court pleases. Yes, yes. Just to emphasize the point, the wording in the section only refers to foreigners. And we know foreigners are those that are not citizens, but illegal foreigners are those that are in the country in contravention of the Act. They are specifically excluded from Section 31. And we know that the Act goes further to tell us what must happen to illegal foreigners. And this needs to be repeated in this court because sometimes it does appear that these are not coming from the Immigration Act. They are just coming from people with other intentions. Section 32 specifically tells us what must happen to an illegal foreigner. And any illegal foreigner shall depart unless authorized by the Director General in a prescribed manner to remain in the Republic pending his or her application for a status. Subsection 2, any illegal foreigner shall be deported. This is the law, unpalatable as it might sound, but this has been our law, and there's been no challenge to it. So there is a special regime that is meant for illegal foreigners, and we submit with respect that that regime does not include the exemptions which are in Section 31. There has been a mention by the minister and other applicants of special circumstances, and I will focus on the political stability of Zimbabwe. And if I'm not mistaken, my colleague also gave the court an exposition about the possibility of the instability that might come with the coming of the elections the following year. But that with respect, my lady and my lords, the special circumstances that are mentioned in Section 31 cannot extend beyond the Immigration Act. The Immigration Act is not the proper act that you look to in order to admit people who are running away from political instability. That regime, with due respect, my lady, we will find in the Refugees Act, my lady, And when I referred my lady to an extra FA2, part of those 4 main reasons why the minister considered this 31 exemption, part of the reasons was to alleviate the refugee system of South Africa, which it's undeniable that is overloaded. But based on the fact that the refugee regime is overloaded, one does not need to leave the principle of legality and the rule of law. One needs to apply the law that is applicable. If the law is not enough, one must approach Parliament to get that law. We submit in the definition of the Refugees Act, a person that qualifies as a refugee. I'm not in any way arguing that if these interested parties in this matter are applying for refugee status, the application will be positively or negatively included. I'm just making this as a point that if you are dealing with a political instability, people who are not in their country because of political instability, you don't use the Immigration Act. The definition of a person who qualifies for refugees is found in section 3 in brackets A, B, and C of the Refugees Act. But in passing, it says, for a refugee status for the purposes of this act, that a person owing to a well-founded fear of being persecuted by reason of his or her race, that's not the case, gender, that's not the case, tribe, religion, nationality, that's not the case, political opinion, this might come close to what we are talking about, because it has been common cause that the issue is the political stability or the instability of Zimbabwe, or membership of a particular social group is outside the country of his or her nationality and is unable and unwilling to avail themselves to the protection of that country, or not having nationality and being outside the country of his or her former habitual residence and is unable and owing to such fear unwilling to return to it. And there are others that deals with the regime of refugee status. The point that we want to bring to the court is that if the minister, if the other applicants are highlighting the political instability, and the court was even given an example of the impending elections that are coming, the Immigration Act is definitely not the right place. And the minister, being the custodian of all this legislation, should have, we submit, referred to the refugee status. May I refer back to that paragraph 20 on page 055-11, where we are given 3 regulations. We are given Regulation 28, Regulation 29, and Regulation 30.
Sorry, I don't follow you. Where are you exactly? What document are you on? Because the reference that you've given does not deal with it.
It is paragraph 20.
Paragraph 20.
Yes, of the answering affidavit of the minister, and it is 055-11. That is the case line reference. I'm told that my junior has directed you, but he might be having problems. So paragraph 20 reads as follows. The minister's powers to grant exemptions are, I do apologize, I'm reading it for the second time. But it says those powers are contained in Regulation 28, 29, and 30. And one just needs to go to those regulations in order to find out if indeed those regulations give the minister the power. The first regulation will be Regulation 20. Regulation 20 simply states an application in terms of Section 31, 2B of the Act shall be made to the minister in terms of Form 47 illustrated in Annexure A, supported by reason for that application. Full stop. And that's what Regulation 28 says. Nothing about the power. It only directs whoever wants to benefit from this section to a form that must be completed. Now, the second section that the minister states that they are entitled to and they're empowered is in Regulation 29. That is, Regulation 29 is read as the heading is a waiver of prescribed requirement. And it refers to Section 31(2)(c), not B, the one that they say they're referring to. It says an application contemplated in Section 31(2)(c) of the Act shall be made to the minister in terms of Form 48, illustrated in Annexure A, supported by the reasons for that application. Once again, this regulation refers to an applicant to the necessary form, and that is now in terms of a different section. The last one that they refer to is Regulation 30. And Regulation 30, the heading starts by saying illegal foreigners. And we've already submitted that 2B does not deal with illegal foreigners. And to confirm that it doesn't deal with illegal foreigners, it's only 31(1) in brackets. Oh, yeah, this one even refers to another section, which is 32(1). It says, upon requesting authorization as contemplated in Section 32(1) of the Act, an illegal foreigner who has neither been arrested for the purposes of deportation nor ordered to depart, and who wishes to apply for status after the date of the expiry of his or her visa shall demonstrate in writing to the satisfaction of the Director General that she is unable to apply for such status. B, shall submit proof to the Director General that she is in possession to immediately submit his or her status. Once again, my lady, this Regulation 30 does not state that the minister has power in terms of Section 31(2)(b) to grant the Zimbabwean exemption that is under dispute in this application. So we submit with respect that there was absolutely no power at all for the minister initially to have granted this, and there will definitely be no power to extend them. Of course, we agree with the minister that the first and the second dispensation, that the first one was the DZP and the second one was the ZSP, were separate and distinct regime and have seen their time, that is, they have expired and then they have been replaced. There's no need to re-mention them. But we mention this to show that the minister or the department understands, as it has said, that these regimes are not extendable. Historically, they have been replaced twice, not extended. And I've already read Section 31(2)(b), where the minister is given other powers. That is if the court agrees with the department that Section 31(2)(b) grants the minister the power, which we still submit it doesn't. Even if it gives the minister the power, one will see that the minister is given powers by parliament to either exclude some foreigners and for good reason to withdraw such rights. Those powers are there. One will search in vain for the power to extend. So that power we submit with respect must come from legislation. In terms of our principle of legality, it cannot simply be implied. The minister ought to have that power. Then that will take me to the eau de Graal principle. Firstly, we will submit that we agree with the minister that the previous two dispensations have been done away. There's no need to mention them. Those were never challenged, but they expired. What the ordinary principle does.
Cross reference to the court. Where are you on your heads now?
As the court pleases.
Your heads appears on 059 on case lines. Just cross reference to the court. Where are you exactly now on your heads? Because I'm trying to follow your argument.
As the court pleases. My lady, the argument, the last argument that I'm referring to does not appear in the heads.
So the one you've just made.
The one that I am about to make, the oral argument. It's in case law.
So if it's not on your heads, then how's the court to follow this now? Are you going to file a supplementary head? The thing is, we need to follow your argument, and we're not here just to write down everything frantically. That's why we ask parties to file heads before the time.
As you may please the court, my lady, we have submitted extensive heads dealing with our submissions. The last point that I wanted to make I will leave it and I will go to the address remedy. And I'm not sure whether the court has sufficient time remaining to deal with remedy. As my Leonard Jr., Mr. Mtsweni, will address that last point. We have dealt with remedy in our heads of arguments.
Sorry, Mr. Majapela, I was not suggesting you can't deal with it. I was just trying,
Yes.
I said before you that if it's not dealt with in your heads, as you say now, then you're welcome to file a supplementary head for the benefit of the court. But we wish to follow your argument, and we have the benefit of the heads that have been uploaded up until now. If you're dealing with another argument now, or an additional argument, then that invitation is extended for you to file an additional note. We're open to that. We just want you to cross-reference it for the court. That's all I'm trying to put across.
Okay, thank you, my lady, for that gesture. We will file a short heads dealing with the Odekral principle, but it's a very short submission. Our submission, and we will file those heads with the leave of the court, if the court grants us that leave. It is simply the following. The Odekral principle does not necessarily say that if a regime or a decision in this particular circumstances, the Zimbabwean exemption permit was never challenged initially, then that is lawful. It does not say that. And that, my lady, with your leave, we will submit a short note in the overnight dealing with that point. We will be referring to the Tasima judgment. And also the Merafon City judgment. If we are granted leave, my lady, that will be the last point that I wanted to make submissions on before Mr. Mtsweni takes the court on our suggestion on the remedy. May I just move the seats? I beg your pardon, my lady.
I'm saying it's fine, thank you.
Okay.
May it please you, my lady, I hope your leadership and the judge and the colleagues can hear me. My lady, following upon our submissions, the next question that comes, assuming the court is with us on the arguments made by Mr. Majapelo on the invalidity of the scheme, we invite the court to then exercise its power in terms of section 172 1B of the Constitution, which involves a measure of a discretion, in that your leadership and your brothers are asked to make an order that is just and equitable under the circumstances. Your leadership would have noted that from our notice of motion, we did not specify what relief would amount to just an equitable remedy, because at the time, amongst ourselves, we were pondering as to what would constitute just an equitable remedy in the circumstances. However, in the course of drafting of our submissions, we came up with what we consider to be just an equitable remedy. But before I tell your leadership and your brothers as to what that remedy is, may I burst your eardrums by at least invite you to the principles which the court must take into account in the exercise of that powers. And I believe that the starting point would be what was said by the Constitutional Court in the EFF case, that is Economic Freedom Fighters and Others versus Speaker of National Assembly and another. It's a 2018 decision and is found in volume 2 at page 571 of our heads, where the court stated in no uncertain terms that in the court making its power of declarations of in exercise of this court, the court must, its powers are much wider. There are no restrictions or conditions. What it means is that you must make an order that is just inequitable, and that order might be so wide. And the section also allows you to make an order that is so wide, that's so wide, and which does not even follow any of the prayers made in the notice of motion. But in doing so, you must take into account the following, as was said by the Constitutional Court in the Hoffman decision, that you must, one, balance the interests, which are the various interests that might be affected by the remedy. And in so doing, you must first look at an order that is aimed at addressing the wrong that has been occasioned by the impugned conduct. You must also craft an order that is aimed at deterring future violations. And secondly, that order must be capable of being implemented, being complied with. And fourth, that you must seek to strike a balance, obtain fairness to those who might be affected by the relief. But what is important is that the overriding consideration in the exercise of that power is the principle of legality. And that was I would not take you there, but it's what was said by the Constitutional Court in the Bangonyama as well as in the Ngomane case, that the order itself must seek to first vindicate that principle. Now, my lady and your brothers, you would have noted that from the minister's affidavit, the invitation that eventually there were about, although there were a large number of applicants initially, the current holders of the ZEPs, we are sitting only at 178,000 as opposed to over 1 million undocumented Zimbabweans who are in the country. Now, meaning that the interest, that the rights that the Helen Suzman Foundation seeks to protect, it's only in respect of this 178,000. Others who are not in possession, those are not afforded protection or will not be afforded protection of this law. But what we know is that since the implementation or the announcement of the ZEP regime, it was made clear by the minister that the ZEPs are not extendable. They do not guarantee you a nationality in the country. And that we submit that amounted to sufficient warning to those who applied and were granted the ZEPs, that I must, whatever I do, I must do so alive to the fact that I only have so much lifespan. That from the 31st of December 2021, I will no longer be afforded the protection of the ZEPs. We know that in November 2021, the minister announced that the ZEPs would not be renewed. But what he did is He then afforded them a grace period of additional 12 months, I would say 13 months, because the announcement was made in November, where he said that you must apply for other mainstream visas, which would then entitle you to stay in the country should you believe that you can make out a case for such. And in case you do not have, then I would submit that it meant that you would have to pack up your bags. So now what it means that as of on the 31st of December, the previous year, there was a 12 months grace period afforded to the ZEP holders to now sort out their affairs and get their house in order. Now, we arrived to the fact that, yes, because of this application, most of them are optimistic that the court might find in their favor and eventually grant them the procedural rights that they complain of in the main application. But what we are alive of is that the court cannot simply overnight, now that their fate has been decided, more so on the legality of the scheme, to say pack up your bags and leave, and they might have to wind up their affairs. Those who have businesses, consider selling them. Those who have got properties, sell them, etc. Now, in so doing, we found that, and in fact, as in December, as I was saying, in December 2022, there was a 13-month grace period afforded them because they've been notified. Then comes in December, the minister extended the scheme for an additional 18 months, albeit we say that it was illegal. But the point is, as we sit here, the holders of the ZEPs had almost approximately 15, over 12 months notification of the fact that they would have to wind up their affairs. However, what we are saying that as just an equitable remedy following the declaration of invalidity, although in our heads of argument we had said that it would be, if the court is with us on the main relief that we're seeking, that the interim relief that has been sought by both HSF and COMSA, being that the ZEPs be deemed valid and that the holders be allowed to enjoy the perks. That period, although in their case they said that for as long as the minister will then embark on the reconsideration process. But during the debate with the court, Mr. Butlander said that the court can go as far as giving them an additional 3 months. I'm not sure whether by the 3 months he meant that they would pick up their bags and leave, or they would take up they would try and legalize their stay, or they would then bring a challenge to that subsequent decision. But we submit that following the declaration, it would be just inequitable that the court affords them an additional period of, although in our heads we said 18 months, but given what Mr. Butlander suggested, that we submit that an additional 12 months from the date of the order would be just inequitable to allow, because we say the 12 months because if the court is not with us, then there's no need for the court to even consider the relief sought by HSF and COMSA, because a court cannot review and set aside any unlawful decision or remit an unlawful decision to the minister. But then to afford those who are affected by this to at least try and legalize their stay through other avenues, be it, I would not prescribe to the court, and the court, I don't think we need to prescribe to them as to what kind of visas and under what regime must they be accommodated, that an additional 12 months be afforded to them to do so. And thus, in the premises, we would have asked for an order that, following the declaration of invalidity, that the court makes an order that the ZEPs be deemed to be valid for a period of 12 months, within which period the holders are afforded an opportunity to apply for other mainstream visas or means to legalize their stay in the country, and that they in such period they enjoy the protection that was given to them by Immigration Directive 21 of 2021, which said that those are the protection that even HSF is asking for in their founding affidavit. And in addition thereto, we then ask for costs. We cannot ask for costs against the HSF or COMSA, but we'd say under the circumstances, it was the minister who perpetuated the illegality, and as such, then it would be appropriate that the minister carries the cost of this application. There were 3 counsel briefed on behalf of the truckers and would submit that equally as for the reasons that Mr. Butler advised that this is not a simple case. It was quite an involved case that it was justified for the truckers to engage services of 3 counsel, and thus any cost sought should involve costs of employment of 3 counsel. But then, in the event that the court is not with us, either on the declaration or on the exercise of its remedial powers, we would submit that all that the truckers did in this case was to come and advance their objective being to legalize and ensure that all those who are employed in the trucking sector is employed lawfully, and that trucking as a profession is such recognized. And therefore, what we would ask for that if the court is not with us, then that the truckers be protected by the watch principle against any cost owed that might that could have or might follow in such regard, and that therefore that this submission we make only on the proviso the court is not with us on the substantive relief that we seek in this application, that is to the declaration of invalidity of the ZEPs as well as the subsequent extension. So those would be our submissions insofar as a remedy is concerned, unless there are any questions from the bench.
In respect of your heads, paragraph 6.12.3, you only sought cost against the first respondent.
It is the minister.
The minister, and those costs include the cost consequent on the employment of 2 counsel. Now you're arguing now for 3.
But we although in the head we ask for 2, but we believe that for the same reasons that advanced by Mr. Butland, that the employment of 3 counsel was justified. We're mindful of the fact that that is, of course, the matter within the court's discretion. But we still, even if we get cost of 2 counsel, we'll be happy with it. But if it's 3, then that'll be a bonus, Malay.
All right, let's just find out. Helen, do you have any questions for Advocate Mtsweni?
Thank you very much, my sister. Mr. Mtsweni, your remedial your submissions on just an equitable remedy is that in the event the minister, after, if that's what the court orders, after the minister has conducted consultations and comes to a decision that the ZEPs be terminated or discontinued, there must be an allowance of 12 months for the Zimbabweans to order their affairs if they have to leave the country. Is that
No, the Justice Malinde, what we're asking for is completely different from what HSF is asking for. HSF is asking for the review of the minister's decision not to extend the ZEPs. What we're asking for is something different. What we're asking for is an order that attacks the validity of the entire ZEP scheme. So that's completely different. But what we're saying is that if the court upholds that and finds that the minister could not have issued or accommodated the ZEP scheme under Section 31(2)(b) for one of the jurisdictional requirements, as Mr. Mjapelo had already taken this court through, then it follows that the ZEP scheme forced to be declared invalid, which is what the HSF wants this court to keep alive. Now, in the process, what we say is that it's just inequitable, because the effect of the declaration of invalidity is that there's nothing that protects the holders of the ZEPs. Their stay in the country is unlawful, but we be mindful of the fact that they'd made lives for themselves. They become comfortable in the country. We cannot ask them to leave overnight, but then to accommodate them to wind up their affairs, then the court gives them 18 months, 12 months, during which period they would at least continue to enjoy the same benefits and protection that they enjoyed, as if though the ZEP schemes were declared were valid, but alive to the fact that they were no longer valid.
Thank you very much. And the protection that you talked about regarding the trackers, could you repeat that paragraph?
Justice Malinde, if you go to the notice of motion, either of that is the HSF's notice of motion, if I can just get myself quickly. In the notice of motion, you would have seen that Helen Suzman at paragraph 4, they sought an interim order, but that interim order was on the basis that the court upholds the challenge on the review. And they asked that at paragraph 4.2, what we're asking for is equally the same relief as just and equitable. But then that relief, it says that relief in that case, it was aimed at operating pending the reconsideration of the matter by the minister. But what we're asking for is not pending anything. It is just to allow them an opportunity to find means to either legalize their stay, those who would like to further stay in the country, through applying for necessary documentation. Those who want to leave, then be allowed to leave. But what we say is that because of the fact that they'd enjoyed the comfort of the ZEPs, and there was protection that was afforded to them in terms of Immigration Directive 1 of 2021, which provides, if I can just read this for the court, it says that paragraph 1 says, no holder of an exemption may be arrested or ordered to depart or be detained for the purpose of deportation or deported in terms of section 34 of the Immigration Act for any reason that of not having a valid exemption certificate or passport, and that the holder of the exemption may not be permitted to be dealt with in terms of section 29 or 30 or 32 of the Immigration Act. The second one is that the holder may not be denied entry or departure into the country for the fact that he does not have a valid permit. 3, that the holder of a permit will not be required to produce a valid exemption certificate or an authorization to remain in the country in terms of section 32(2) of the Immigration Act. So we're saying that that protection only be afforded to them for the grace period of 12 months. After the 12 months period, then the protection falls away. Then the authorities would be entitled to deal with them in terms of the law, to the extent that the others have not, those who never legalized their stay through other means.
Thank you, Mr. Mtsweni.
Mr. Mtsweni, perhaps to be fair to you also, you can also upload a proposed draft court order for the court to consider if the court finds in your favor.
We'll do so, my lady.
And at least we have some sort of guidance that you place before us.
Right, please,
Thank you, Judge Mota. Do you have any questions?
Just one comment. Is it correct that your initial stance was 18 months, not 12 months?
Yes, Justice Mota. We had sought 18 months, but having heard what Mr. Butlander said during his debate with this court, where he said, well, you can give us 3 months after the minister's decision, then in that case, we thought we were more gracious than Mr. Butlander is towards his own client. So hence we then believe that 12 months would be justified. Mind you, Justice Mota, the 12 months is in addition to the already, what I would call 13 or 14 months that they'd already gotten since November 2021.
All right. No, thanks. No further question.
All right. Do you have any questions to Advocate Mojapelo? Judge Malinde?
Yes, my sister. Thank you, Mr. Mojapelo. Section, if you can hear me, are you ready, Mr. Mojapelo?
Yes, I'm ready. If I can just put this thing on. Apologies. Thank you, Justice Malindi.
Yes. Section 31(2)(b) refers to special circumstances. And if those special circumstances still prevail at the time of decision to discontinue ZEPs, what should happen if you say an extension is not authorized under the section?
Yes, thank you. The criticism of the special circumstances agreement that we have put was purely on the reason that the focus is on political instability. And our submission is that political instability in our submission has another act that can deal with it. People who are afraid to go back to their home because of political instability should be dealt with in terms of another act. Hence, we submit that it is a wrong section to deal with. The special circumstances, I hear the question. The question is, if those special circumstances still exist, it might justify an extension, maybe. I think the answer there lies in the principle of legality. I think my submission will be that the answer to if the special circumstances still exist, there must be new applications. There's already been a precedent by the expiry of the DZPs, which were replaced by the ZSPs, which have now been replaced by the ZEPs. I'm not sure whether that answers your question, Justice Malindi.
No, that's fine, Mr. Njapelo. My second and last question is for you to assist me to understand your case properly. Is your submission that because Section 31(2) refers to the granting of dispensations on application, it cannot be at the initiative of a minister or government to grant ZEP or ZSP exemptions? And you saying that appears from the section itself, Section 31(2), and the regulations that you referred to, that an application must be made and not at the initiative of a minister.
Yes, Justice Malindi, it is our submission that an application must be made by the person who desires to benefit from the section. The counter argument to our submission will obviously be, upon invitation by the minister, the individuals did make applications, but we submit with respect that application as is regarded in terms of the Immigration Act had to be initiated without any invitation. Hence, we have all these problems according to our submission that illegal foreigners were made to benefit from Section 31 when they were not supposed.
Thank you very much. Thank you, my sister.
Thank you. Judge Mota, any questions?
Yeah, just a few points. Do I understand you well to be saying your coup de grace, as it were, is that the minister referred to illegal foreigners, not legal, when addressing the issue of 31?
Yes. If I understand your question correctly, Justice Mota, the minister used the word illegal, FA2. I've referred the court to annexure FA2, which is similar to annexure FA4. It uses the word illegal.
Mm-hmm.
If I may just find it now.
No, I'm entirely with you.
Yes.
And
it is actually in our submission common cause that this exemption were not granted to foreigners, but they were granted to illegal. And the other word that is used by the minister is to regularize their stay.
Mm-hmm. Now that you have the system that is in existence, which is my understanding of Odekral principle, that it remains in existence until tempered with by the law, you have by the courts, you have this system that is in existence, and it says under D, the minister can only withdraw it for good cause. What's your understanding of good cause?
I beg your pardon.
Read D 31 to B, and I think also D.
For good exemption granted. Yes, I found it.
Yes. Now,
Yes.
I want you to help me here because
Firstly,
my extrapolation of what good cause means would obviously include some form of consultation. And I want to hear from you. What's your understanding of for good cause?
yes. Good cause might mean that the minister, the first example is the one that the justice has given me, that the minister might have consulted and applied his mind. But good cause, the obvious one will be that maybe those reasons that force the minister to grant the exemptions no longer exist, and the minister can say it with evidence that those reasons don't exist anymore. But may I just add another submission, Justice Mota, is that in our particular matter, there was no withdrawal. So the exemption just came to their natural end.
It can't come to a natural end. It states it must follow 31(2)(b). And if you follow it, the minister can bring it to an end as the minister did. And the predicament we all face with is that we don't have an affidavit from the minister explaining the good cause and all. We have basically conjecture based on statements that are made at the Star. I think you have your F813 statements. You refer to F2 as well. So that's the predicament we all face with here. We don't know really what the minister relied on.
As the court pleases, as I understand the court's question is, I think it's still going
for good cause,
intertwined with the previous question that they don't know whether the conditions have come to an end. When I firstly answered that it comes to a natural end, I meant the exemption. Maybe I didn't understand the court's question correctly. But what I meant was, because section 31(2)(b) says for a specified period, and we know the period came to an end. So that was my first answer. But I understand now the court's question to say, how do we know that the conditions came to an end? It is for the minister to tell the court. I am afraid I don't want to get into Mr. Jami's case now. I have no answer. Yes, but in our case, we had a specific period which was 4 years. 4 years has come and gone. If there are certain conditions, the precedent in this matter is that the minister will put another invitation. It will change from, like it has done, change from DZP to ZSP to now ZEPs. So my submission will be, if there are still conditions persisting, the minister must or should follow the previous procedures if the law allows, which we submit.
So you're abandoning your whole argument that this is... Okay.
Yes.
All right.
That's
no,
the
that's
difficulty.
Fine. Thanks. No
of
further questions.
Thank you. May I just comment? I accept. That is the difficulty of answering for the minister, my lord, because my case is simply that the minister was not entitled to, but I had to spoil or to mess up Mr. Jami's case by answering on behalf of the minister. I'm not abandoning my case. Thank you, my lord.
I'm sure Mr. Jami will be asked the same question. Thank you, Mr. Jafedo.
As the court pleases.
We've gone beyond the allocated sitting for the court day. It's now 4:20. Mr. Jami?
As the court pleases, Justice.
Will you then proceed tomorrow morning? With the allocation of the time left for this hearing, will we finish within the allocated time? Or do you think there's a need for us perhaps to start slightly earlier than 10 o'clock?
I'm just conferring with Mr. Rosenberg, and we expect to finish well within the time allocated, Justice.
All right. So we'll start it at 10 o'clock, and then you can proceed, Mr. Jamie, with your argument.
As the court pleases, and just by way of preface, Justice, it'll take more than that to mess up my argument. So I'll see you in the morning.
We take you to have a very strong argument to put forward.
I'm killing you, Justice.
All right. Thank you. So we'll reconvene then tomorrow. That's the 12th of April to continue with this argument, the hearing of this matter. Thank you.
As the court pleases.
As the court pleases.
As the court pleases.
As the court pleases. I have to go and fetch my car.